Judgment item 41.
Writ petition is allowed.
I told you it's like an exam.
Huh?
I told you it's like an exam, whether you pass or fail.
Yes.
But just that accommodation, if you watch item number 14, 15, and 16.
Item number
14, 15, and 16, man.
14, 15, 16. Huh.
It was a very tragic incident that happened. Petitioner was about to come to my chamber. His son expired.
Oh.
So I think slight accommodation. I took the consent.
14, 15, 16.
Yes.
Okay. No, this is with regard to that. Okay.
Oh, this is a contractual matter.
Right. On the prayer for adjournment made by Mr. D. Das and Senior Counsel, who submits that the petitioner's family, his son,
Yes.
was involved in an accident. But the matter is adjourned for 2 weeks.
Completely.
This is the matter after 2 weeks. Right, then you want 9th, it's okay. 9.
For item number 20 is concerned, ultimately BTC.
No, what is about wait, that 10th is it's about what? From 22. 9th, 11th.
So for item number 20 is concerned, ultimately the BTC authority has released the bill.
Oh, very good. 22.
20.
Right. Mr. Ardhar submits that the writ petition has become infructuous in as much as the bills of the petitioner has been released.
Yes.
Who appears for the BTC? Mr. B. Hazarika appears for the BTC. In view of the submission made by Mr. Ardhar, the writ petition is dismissed as infructuous.
May I please also, with the consent of the other side, I'd like to mention item number 29 and 30, my lord.
29, 30, yes.
Taken up next week, my lord.
Why?
Arguing counsel, Mr. Ayalaman is not well, my lord. Next week, my lord. I think, my lord, the records have already been received by the government bank. Yes, ma'am.
Right. Okay, right. A general prayer has been made on behalf of Mr. I. Alam, counsel for the petitioner, on the ground that he is unwell. Accordingly, place this matter on 12th. The matter pertains to that suspension of the fair price shop. Yes,
Fair price shop.
that's right, full stop. The matter pertains to suspension of the fair price shop license of the petitioner.
Alright.
Then this is the matter on 12th.
May I please, Your
Yes,
my lord, I would like to mention item number 18, one is,
yes.
my lord, Mr. R. Sensor is out of station, my lord. I prepare only passport for a day. I have taken consent from the other sellers. If is also with him, lordship.
You're there also?
I'm not there. My name is D. Govil.
Okay, right. Adjournment prayer has been made on behalf of the petitioner. Who has apparently been evicted from railway land. This is the matter. When? There's the order.
No.
This is the matter. 12th. This is the matter on 12th.
Hello, Miss.
He had a heart attack. But he's sitting over the money. He's sitting over the money. How come he's had a heart attack? He doesn't want to give it out. But you have not given the money, madam. Who's for the petitioner? Have you? Yes, they're asking for time.
Okay, Lordship.
Okay, right. Ms. S. Kemprai prays for time on the ground that the joint secretary, the concerned joint secretary has had a heart attack. She submits that she needs, how much time? 4 weeks time, madam. This is since September, we've been pushing you to give the money.
Lordship, after vacation.
But he's sick. He got a heart attack also. Yes, I forgot about that.
After vacation.
Yes, she submits that she needs 4 weeks time to file affidavit, additional affidavit to clarify the the pata of the petitioner. List the matter after 4 weeks.
Obliged, Lordship.
Actually, I'm paying for listing of this matter in the admission for my matter pertains to non-payment.
Date.
Easy.
Who's for the petitioner? You're taking the consent?
Yes, I'm taking the.
You're taking the consent? Your name is Mr. Bidas, appearing for the APDCL. Item 30? This is not a APDCL matter. This is with regard to that new market, It's with regard to a market. It's not with regard to APDCL. APDCL is 4011 is 32, not 31. We nearly adjourned the wrong matter. Oh, shifting of transformers, yes. You have put the transformer there. Why don't you shift it? Huh? Why should they pay? Why shouldn't you do it free of cost? Correct. That's an issue then. But y'all are wasting time this way. One last chance. Mr. Spencer is counsel for the APDCL is given one last chance to file affidavit in opposition. List the matter after the vacation.
May I please, your lord? With respect to item number 39, my lord.
39.
39, my lord.
Yes.
The review petition, my lord, and IA has been filed by us in this review petition. My lord, the same is not in the record, so I may be allowed to bring the same.
Okay.
Obliged.
May I please, your lordship? I need to mention item number 28 with the consent of other side, my lord, for the adjournment.
Right?
Where I am the respondent number 5. After filing Bagalat today, same impairment.
Okay, you are respondent number 5. You have been selected.
Yes, I am.
Have you spoken to the petitioner?
Yes, I have taken consent from the
Okay, Mr.
AK Azad.
AK Azad appearing for the respondent number 5 is granted
2 weeks, man.
3 weeks time to file
3
affidavit in opposition. List the matter after 3 weeks.
Please, Your Lordship, I beg to mention for withdrawal of WPC 18282.
Tomorrow?
Obliged, Lordship.
Mayor, on behalf of my senior, I am on WPC 20. On behalf of my senior, I am listing this matter, the last date on 24/9/2024. May
So when do you want?
6.
6.
Yeah.
Okay. Pardon.
Much.
Your lordship, with regard to item number 36, your lordship. Item 36, it's a old contempt matter, lordship. But at least 2 weeks time may be granted, lordship, because in the meantime, there must be a change of the officer, your lordship.
Not only change of officer, there is unserved notice from the respondent number 3. The notice issued to the respondent number 3 has remained unserved, has returned unserved.
I apologize, I haven't checked the office note.
Then if you have checked, then there's no point keeping it pending unless you see, 2018.
Yes, Lordship.
I don't know if you're
Sir,
not
these are
pursuing the
all-
matter at all.
These are all forest royalty connected matters, Your Lordship, because the courts have, in the meantime, courts have already directed that in absence of any clause in the forest royalty, in the tender.
No, there's no point adjourning just for the sake of adjourning. Let's be very clear.
It should come to a conclusion.
Give me that item.
There were several inflictions, Your Lordship.
There are altogether three contenders.
Three contenders.
One is
Initially, there was one.
M Buck, he's gone.
Yeah, initially one.
Then there was this
Forest Chandra.
Sri Paresh Chandra,
Yes, Lordship.
he's also gone.
Yes, Lord.
Now there is one Kalyan Kumar Sarma.
Yes, Lordship.
Now, whether he's also gone.
Perhaps, Lordship, I have to take instruction, that's why.
Probably he's gone by now.
That was in 2021, Your Lordship.
Then, now it's 24 end.
IA 2360. Lordship,
What is to be done?
Lordship, to close also, Lordship,
Huh?
I must take some,
Just give me this IA.
IA 2360, Lordship.
260. So he was implemented in February 2022.
Yes, Lordship. 7th of February 2022.
Right. As per office note. Dated 13/11/24, there is the notice issued to the respondent number 3 has returned unserved. So, sir, the respondent number 3 had been implemented on 7/2/2022. Combined as much as the respondents 1 and 2 had left the post of executive engineer PHE, the PWD, Guwahati NH division, and had subsequently been replaced by the respondent number 3. So, sir, the petitioner shall ascertain as to whether the Mr. NJ Das, the learned counsel for DJ Das, the learned counsel for the petitioner shall obtain instructions as to whether the respondent number 3 is still holding the post of EEPWD Guwahati NH division and take appropriate steps for
If there is.
take appropriate fresh steps for issuing notice on the respondent number 3. Full stop. In the alternative, the petitioner may have to file an impediment application if the respondent number 3 has been transferred out
If Lordship.
or retired.
Yes. Much of.
List the matter after
2 weeks, Lordship. In
2
the
weeks.
meantime, I will.
Withdrawal item 47.
Lordship, with respect to item number 47, I have instruction to withdraw. Rest will remain. The issue is different.
Huh?
Issue in other writ petition is different in my writ petition. I file application.
So yours only WPC 1206.
Lot.
Others don't need not be with us. Okay, right. Mr. FCKL, learned counsel for the petitioner, submits that he received instructions to withdraw the writ petition. Mr. B. Das appears for the APDC. On the prayer of Mr. FCKL, learned counsel for the petition, the writ petition is dismissed as withdrawn. Then what about this other item?
This item will remain. So the issue is different. In that case, excessive bill was raised by the.
Huh?
Excessive bill was raised by the APDSC and different council are repairing in different cases. My case was with disconnection of my electric connection that has been disconnected. They still remain.
Item 43 to 47, you say. List this matter on 12, 13.
Much.
12. Only item 42.
Release for motion item 1.
Yeah, file an affidavit, it's not here.
I have received just now, your lordship.
Okay, then, so you want to file something? No.
Not-
What? You want to
Reply,
file?
Reply.
Okay, Mr.
Elmo.
Well, Mohan, learned counsel for the petitioner submits that affidavit in reply has been, affidavit in the position has been served to him this morning. Accordingly, prays for. How much time?
2 weeks.
2 weeks time to file affidavit in reply. Praise aloud. This is the matter after 2 weeks.
Yes, Lordship. Lordship, affidavit has been filed.
Yes, madam. Ms. D. Angana, learned counsel for the petitioner submits that the petitioner's contractual dues amounting to rupees 11,28,120 has not been paid. Issue notice returnable in 4 weeks. Ms. D. Jane accepts notice on behalf of the what? 1 to 4. Petitioner takes steps for service of notice upon the respondents number 5 and 6. By registered post with AD within 3 days. This is the matter of the 4 weeks.
Item 3.
Yes, yes, yes.
I think under consideration, my yes, with the need, we put some more time.
Okay.
I think the, any kind of.
Okay. Right, Mr. P. N. Goswami, learned counsel, learned AG or additional AG. The additional AG submits that the respondents need a further time to take a call on the petitioner's representation dated 18/11/2024. Accordingly, list the matter on when? 13.
Item 4.
Yes. Huh?
Respond number 2 is the authority where the computers are placed.
Whether? Who has
Computers
been?
are placed. One is the one who has called the tender, invited the tenders, my lord. Only thing
Who,
is that
who has disqualified you?
the education department, my lord.
The number 1.
Number one.
Yes. Yes.
So NIT is the one where the computers are being placed. If they are taking a stand that they have no role to play, I mean, that may be recorded. That may be recorded.
Then what to do?
We'll file the independent application. Only on the short, I'm not on the,
I know, that's the only
the
thing.
only short point.
No, why don't you just withdraw and file again and we will issue notice straight away?
It will be recorded.
Okay, I'll record that. Yes.
Let it be recorded.
No, you pray it and then we'll record it also
Because of this.
because of this.
Because of this. Very good.
Because then it becomes easier. Because the only issue is whether it is, can be done in perpetuity or not. That's all. There's nothing else. Right, Mr. S. Datta, learned counsel for the respondent number.
1.
Do you permanently learn counsel for the respondent number 1? Submits that the bid dated 28/8/2024 had been issued by the Ministry of Education, Government of India, and not by the state government, not by the Department of Higher Education, state government. Huh? That's what Department of Higher Education, Government of Assam. He accordingly submits that the disqualification of the petitioner's technical bid has been done by the ministry Then,
They did the necessary party for.
and he accordingly submit that the education, Ministry of Education, Government of India would be a necessary party.
And that they have no role to play.
And that the
Same
Department
was
of Higher Education, Government of Assam does not have any role to play
Any
in the
role.
disqualification of the petitioner's technical bill.
Very good.
Full stop. Next para. Mr. S. Banik, learned counsel for the petitioner submits that in view of the submission made by Mr. D. Upamanu, learned counsel for the respondent number 1, he would like to withdraw the writ petition with liberty to file afresh by adding the necessary parties. Correct? The prayer of Mr. S. Banik is allowed, writ petition dismissed as withdrawn, comma, with liberty as plead for. Mr. Miss S. N. Bora. Miss M. Bora for respondent number 2. Miss M. Bora appears on behalf of Mr. S.P. Chaudhary, learned counsel for the respondent number 2.
Right.
Any instructions?
They will have.
Have you got any instructions? Are you sure? Your senior doesn't have any instructions. Is he coming? Then we'll wait.
Absolutely.
Let us wait, because if he has instructions, if he has instructions, then maybe we can decide.
It cannot be for
But
perpetuity.
yes, that is all.
That's the point.
That's the only thing is, but if he doesn't have instructions, then better for you to withdraw and
Very good.
because naturally
Fine.
necessary party is the thing. Yeah. Yes, pass over time, but keep that order, huh?
Regarding issuance of stamp vendor license. I have application, my lord, on 14/10/2020.
A stamp vendor license can be applied for by anybody,
My lord,
is it? Is there some parameters or how this has to be given?
no, my lord.
Can, or anybody can just apply and he can begin?
No, my lord,
What are the eligibility criteria for a stamp vendor?
Police verification as well as my.
Mr. Counsel, please understand, forget police verification, just tell me, what is the eligibility criteria required for a person to be given the stamp vendor license?
My lord.
What is the eligibility criteria? Anything? Any rules? Any?
In the act, there is the only section.
Let us see. What does the act say?
The Act 74 says that, my lord, the powers to make rules relating to sale of stamps. The state government may make rules for regulating the supply and sale of stamps and stamp
I don't know.
papers.
Yes, what is to be done here? He is saying that he has applied.
Applied.
Is that?
There is a statutory by your SIT.
Ah.
It's a Corporation of India. Now, my lord, we have made a presentation for the deputy commissioner. And of taking the stamp vendor license. So you can find out to second authority and then back to the revenue department. The revenue department has now forwarded to the Corporation.
Okay.
That constitutes finding the last page of the receipt, page 14 and then 30. Page 14 and then 30. So they have their own parameters. And then
Okay.
Now, the corporation are 5 out here. So
Huh?
are
R5.
5 out here.
Lordship, one thing.
My lord, please attend, my lord, tell. It is they who are going to, my lord.
Take a decision.
However, that's what my instruction goes, my. The stockholding, my lord, they are saying that if one having stamp vendor license.
Huh?
If someone is having stamp vendor license, then they will give him e-stamp vendor.
They will give you?
E-stamp. What, my lord? This is the.
What?
E-stamp.
They will give you, why should they give you e-stamp license?
Only those having stamp vendor license.
So yeah, unless you have stamp vendor license, you cannot have that e-stamp vendor license. So I don't know you. Right. Heard Mr. J. Laskar, learned counsel for the petitioner who submits that the petitioner has paid for a stamp vendor license under the Silchar Sadar Circle. However, despite the application of the petitioner being considered by the authorities, no decision has been taken by the respondents till date. Issue notice returnable in 4 weeks. Ms. R. Pujari accepts notice on behalf of respondent number 1 and 2. For about 3 and 4, Ms. Yudas accepts notice on behalf of respondent number 3. Petitioner to take steps for service of notice upon the respondent number 5 by a registered post with AD within 3 days. List the matter after 4 weeks. Right.
Item 6.
Very limited prayer, Lordship.
Huh? We'll give time. You just, he's got enough, his lease is for long term. Okay. Heard, Mr. MK Hussain, learned counsel for the petitioner who submits that the petitioner was settled with the 47 number Morakolong Mean Mahal, Moregaon district for 7 years with effect from 1/4/2022 to 31/3/2029. Gustav, next para. The petitioner's counsel submits that though the petitioner executed an agreement dated 7/10/2022 with the AFDC for the fishery, the possession of the fishery was handed over to the petitioner only on 11/10/2022 instead of 1/4/2022. The petitioner counsel submits that the petitioner has accordingly submitted a representation dated 27/5/2024, praying for adjustment of his revenue for 193 days due to the late handing over of possession of the fishery. He submits that the writ petition can be disposed of if a direction is issued to the respondent number 3 to take a decision on the petition's representation dated 27/5/2024. Mr. P. Sharma, appearing for the AFDC, submits that he has got no objection to the prayer made by the petitioner's counsel. Next para. In view of the consent of the parties, the respondent number 3 is directed to take a decision on the petitioner's representation within a period of 1 month from the date of receipt of a certified copy of this order and communicate the decision to the petitioner. The writ petition is accordingly disposed of.
Item 7.
And this petition is for due to non-completion of tender process, Lordship.
Not completion.
Non-completion. Already CS.
Yes, why don't you complete? Why are you not completing? I don't know. So do we issue notice or we instructions? Notice, so everything will go for a 6. But okay, Mr. MK Hussain, learned counsel for the petitioner, submits that the tender process initiated on 29/5/2024 for settlement of number 161/163/164 Khanda Jan/Sideli/Gatwa Group Mean Mahal, Moregaon district for 7 years has not been completed till date. He accordingly prays that a direction should be issued to the respondents to complete the selection process pursuant to the NIT dated
29/5/2020.
29/5/24.
2024.
Mr. P. Sharma, learned counsel for the Fishery Department, shall obtain instructions with regard to the above. Miss Udas also. And Miss Udas. Miss P. Sharma for Fishery and Miss Udas for respondent number 3, 3, 3, 5, and 7. Shall obtain instructions with regard to the above. This is the matter on 18. Heard, Mr.
Yes, ma'am.
S. Nath, counsel for the petitioner who submits that the petitioner's contractual dues amounting to rupees 22, 40,988 has not been paid. Issue notice returnable in 4 weeks. Ms. D. Jane accepts notice on behalf of all the respondents. List the matter after 4 weeks. Then you can say that you can say that there's no liability. Then he'll have to do it. Huh? So yes, where is your work liability certificate?
They will verify, ma'am. I have the bills, man. Certificate I have not received, but.
You see, you take whatever steps.
Bill has been countersigned by the.
This is a matter of the police.
Public.
Right, Mr. P.K. Mukherjee. Then counsel for the petitioner who submits that the contractual dues, 15,33,473. Issue notice returnable in 4 weeks. Ms. Udas accept notice on behalf of 1, 4, and 5. Mr. H. Raban. S.R. Rabah. Accept notice on behalf of 2. Who is finance? Mr. P. Nayak accept notice on behalf of respondent numbers. You can take for finance and PWD. For PWD. And you for finance. P. Nayak for respondent number 3. And Mr. B. Gogoi for respondent number 6. This is the matter of the 4 weeks.
Pendency may not be a valid definitely.
Item 10.
Okay, right. Heard, Mr. Heard, Mr.
Yeah, Khanikarwar.
A. Khanikar, learned counsel for the petitioner who submits that the petitioner is owner of plot of land under dark number 2277 owner of land measuring 1 katha 3.92 lechas under dark number 2277 pata number 1738 of Revenue Village Sahar Sarania Part 2 under Ulubari Moza in the district of Kamrup M, Assam, along with other co-partners. The petitioner had applied for building permission up to ground plus building permission, not up to. It'll be permission for ground plus 2-story building on 6/10/2024. Wide reference number so and so. It is here in the synopsis. The petitioner's grievance is that the respondent authorities have insisted for payment of 2% forest royalty on the total cost of the building for issuance of the building no objection certificate / permission. As per government notification, government communication dated 2/3/2023 issued by the Joint Secretary to the Government of Assam Mines and Minerals Department. The petitioner's counsel submits that the impugned communication dated 2/3/23 has already been set aside by this court in WPC 4085/2024. And as such, the respondents cannot deny the grant of building permission / NOC on the ground of non-payment of 2% forest royalty. Mr. D. Gogoi, learned counsel for the Forest Department. And comma, Miss Udas for respondent number 4 and 5, and Mr. P. Nayak for 3, 6, and 7. Submit that. The present case is a covered case in terms of WPC 4085/2024 and 5049/2024. And the petitioner is not required to pay any forest royalty when when he's constructing a building on his own land. On his own land. Next. On perusal of the next the operative portion of paragraph 19 of the judgment and order dated 24/09/2024 passed in WPC 4085 of 2024 is reproduced here and below as follows. Para 19. That is at page 41. Okay. Next para. In view of the fact that this case is a covered case and as the impugned communication dated 2/3/2023 issued by the Joint Secretary to the Government of Assam, Mines and Minerals Department has been set aside, the prayer of the petitioner is allowed. The respondents are directed and the respondents are accordingly directed not to insist not to ask for payment of deposit of 2% forest royalty, and they should grant the necessary permission / no objection certificate, unless the same is not permitted due to some other ground. The writ petition is accordingly disposed of.
Timing at a court.
I'd like to withdraw it with liberty to refile.
Huh?
I'd like to withdraw it to
Okay.
liberty to refile.
In view
In view of that.
in view of that. So Mr. S. Banik, learned counsel for the petitioner submits that in view of the submission made by so and so, he would like to withdraw the writ petition with liberty to file afresh after impleading and the necessary parties. Writ petition accordingly dismissed as withdrawn, with liberty as paid for.
Item 11.
Wait with the council. Here we are challenging the time barred reassessment order and the recovery proceeding order.
You are challenging what?
Time barred reassessment order as well as the recovery proceeding order.
Where is your representation?
Lord,
Where is your representation against that? Where is your challenge to that? Is there an alternative remedy or what is this?
no, Lord, this is the statutory bar, my lord. If your lordship would see section 40, subsection 2.
Where is your representation?
But I am not required to file any representation. I am
No.
challenging the.
When you challenge it, can you challenge it directly before the
Yes,
court?
yes, because under the statutory, my lord, there
Is there an alternative remedy?
no, because it's barred under the law, my lord.
What?
If the statutory provision has been violated, that's why, my lord, I have come before your lordship. If your lordship takes subsection 2 of section 40, my lord, of the Assam Value Added Tax, I have also quoted, my lord.
Yes, who is appearing? I don't know. When there's a bar, I think you should have approached them also saying that you have
No, my
passed
lord,
an order.
as regard assessment, only other remedy would be appeal on the factual aspect of it, my lord. But when there is a statutory.
When you come to a writ court,
My lord,
you see, this is not under your whatever this act. This is under 226. So it's a duty for you to submit a representation to them
the
also.
representation will not work in the matter because it's not my submission before lordship says that this assessment order as well as the recovery proceeding is barred under the statute.
Maybe barred, so you can inform that this is barred.
My lord, that illegally they have passed. That's why, my lord, the remedy.
Maybe everything, you see, all the writ petitions that come here, it's not against, it is not the case of the petitioner that these are all legal orders.
Rightful, right from whirlpool decision, my lord.
Maybe.
If it's a statute, if your lordship would kindly.
You see, all statutory problem, you see, all challenges to a statute anywhere doesn't bar you from submitting a representation first to the authorities.
My lord, representation will not work, my lord.
Whether it works or not, we do not know. You cannot take the role of the authority.
Lord.
You file a representation, they will decide whether it will work or not.
My lord,
Who are you to say that it
No,
will
no,
not
not-
work?
there is a scheme of challenging of the things, my lord. So, my lord, in that scheme of things, representation is not the remedy. My lord, remedy are twofold. Either I file an appeal or I approach your lordships in a writ proceeding.
And
Now-
before approaching this court, why
My-
don't you file a representation?
My lord, because the assessing authority does not have power to review his own, my lord. It's a quasi judicial order, my lord.
You could have said that to the authority or to the authority higher than that authority.
My lord, then I'll have to go for appeal, my lord.
Then
Then, my lord, that would be an alternative remedy. But
Then-
when, my lord, there is a, my lord,
that means there is an alternative remedy.
no, Lord, that is not efficacious because it's a, Lord, your lordships knows what are the exceptions coming before your lordships. Lord, if there is a violation of the statute, I can come before your lordships.
You can. There's no bar, but
That is my
that
case.
doesn't mean that we have to, exercise that discretion.
I'll have to satisfy your lordships on that.
It's a
count.
discretionary power. Even if that alternative remedy is there, it's still a discretionary power.
Lord, so far as violation of statute is concerned, Lord, your lordships have entertained petitions.
Correct. The Supreme Court is there,
Yes,
Whirlpool
yes.
is there. That is not the issue.
Lord,
But what I'm saying is this is a discretionary power.
Lord. Now, if your lordship would come to page 16, my lord, I
Yes.
have quoted the provision. Subsection 2 of section 41. At the bottom, no order of assessment and reassessment shall be made under subsection 1 after the expiry of 8 years from the end of the year in respect of which part of which tax is assessable. Lord, the relevant Lord assessment year is 2007 and 8, Lord. If your lordship kindly take up
Let
this,
us go to one first.
my lord.
Oh, one second. Okay. After some time.
My lord.
This is regarding outstanding my lord, deed selling. It's a covered case, my lord, we passed the order at page 20.
What to do? Same. Okay, it will be heard, Mr.
J. Sharma.
J.
Sharma.
Sharma, learned counsel for the petitioner. And Mr. P. Nayak, counsel for all the respondents. So, now out here, the package, what is the package number?
Yes.
90? One. Package number is C and D /D/V /08. Then notice to proceed with work is what date?
That is my lord will find.
18/5/21.
Yeah.
18/5/20.
Yes,
Okay,
yes.
notice to proceed with work 18/5/21. Okay. Then show cause notice is 10 page 10/6/2021.
Yes.
Your reply is Huh?
Reply is 10/6 and so cause notice is 18/6.
show cause notice 18/5. How can it be 18?
18/5.
Show cause notice 18/5/2021. Reply is 10/6/2021.
10/6.
Then how much is the work completed out here?
That is in,
Will be measured. Yes, will be measured. So as per the measurement already done. Okay.
but here
Then-
it is 20. No, here.
No, but then we will assume that it is done.
No, it is my lord.
If it is done.
It is there, my lord, in page 17.
Just a minute, just a minute.
25 to 30% have been completed. Page 17, annexure E, my lord.
17.
Yes. 25 to 30% works have been completed so far.
We will see. We'll keep that blank. Let him decide. Okay. Where's the termination letter? That is 12/6/21, same thing.
Page
That's same.
19.
Okay, that's same. Okay, it will be the same thing except for these changes in page 20 to 20. That judgment is there, huh? Page 20. It starts. Okay, same thing. Before.
Supplementary motion 48.
No, it will be. Yeah. Yes, Mr. Data, as per the judgment. Okay, right. Heard, Mr.
Irama.
B. Raman, learned counsel for the petitioner. And Mr. S. Data, learned counsel for the PNRD department. Ms. Udas appeals for. That's point number 2. The petitioners had collected documents for submission of tenders pursuant to the NIT dated 30/05/2024 for settlement of the Bechimari Daily Vegetable Market, Bechimari Weekly Cattle Market, Bechimari Weekly Open Market, and Bechimari Bus Parking under the Bechimari Ancharik Panchayat, Darang Zilla Parishad, Darang District. However, before the last date of submission of tender, which was 15/7/2024, the tender process was cancelled via notification dated 29/6/2024, issued by the
Principal Secretary.
Principal Secretary to the Government of Assam, Panchayat and Rural Development Department. Pustak. By the said impugned notification dated 29/6/2024, it was also decided that until new tenders were finalized, the existing lessees may be given extension of the markets, ghats, fisheries, etc., at the settlement value fixed for the year 2023-2024. Full stop. Next paragraph. The petitioner's counsel submits that a challenge had been made to the impugned notification dated 29/6/2024 in a number of cases, the lead case being WPC 5993/2024. Next paragraph. This court, by common judgment dated 29/11/2024, disposed of the batch of writ petition, the lead case being WPC 5993/2024 by giving the following observations and directions at para 37, which is as follows. Take this para 37. Next para. In view of the petitioner's counsel submits that the present writ petition can be disposed of in line with the observations and directions passed in para 37 of WPC 5993 of 2024. Next para. Mr. S. Datta, counsel for the PNRD department, and Ms. Udas for the respondent number 3, submit that they have got no quarrel with the submission made by the petitioner's counsel. In view of the consent of the parties, this writ petition is disposed of in line with para 37 of WPC 5993/2020. Accordingly, the Bechimari and Charik Panchayat are directed to complete the selection process, the tender process in terms of the NIT dated 30/05/2024 Within? Is there any period given? At the earliest, and not later than 3 months from the date of receipt of a certified copy of the form. So as
The last part, my lord.
it said preferably. This is 29/11. Huh? Okay. Okay. So now who has to do it? It is the Angelic Panchayat only. You have to do it. Everyone has to do it. So within 3 months. No, both of you.
Yeah.
Oh. What decision is to be? What decision has to be taken? No decision has to be taken by the government. Once the 29/6 has gone, that you do whatever. I'm not talking about the NIT. I'm talking about the tender only. I'm not on the thing.
Completed tender process.
After the final modified tender, only they can issue the tender.
Correct. That is a different issue. As on date, the completion of the tender process that should be done. The finalization of the new tender process and the NIT, that will follow this judgment.
That was only, yes, only at
Only with regard to the,
point 3 point has already been given. The respondent authorities are directed to run the.
only the third point.
Highlight the tender process. Yes.
This direction was for government to do their act. Thereafter, because this is continuation of 1, 2, 3.
What, 3, my lord?
Okay.
Point 3 is direction to the actually Panchayat. Continue.
Okay. So we cannot give them also.
Because after completion of 3 months by the government.
Okay. So what have I said? No, cut that. So what have I said just before that? That's all. So the writ petition is accordingly disposed of. It is here, huh? 37. Oh, 2. Miss, you asked for 2. Okay. 13. 1-3.
1-3.
That's what you said last time.
This is, I respectfully and most humbly and respectfully like to differ with this submission lordship because I can take your lordship to the previous records. Earlier, they have paid. Page 15 lordship, we can. This is from the same total bill. This is the second installment was paid, particularly. Page.
On giving the function by.
No, I will submit. I will show. Paragraph 3 may kindly be.
One at a time.
Let me.
Yeah, let us wait just a minute before it.
Paragraph 3 lordship.
No, just start from the very beginning. What is the case?
Petitioner is a subcontractor lordship. Is admittedly subcontractor. He was for transportation of some materials of power grid. At page 32, lordship may kindly come.
You are a subcontractor of whom?
IVRCL.
That is respondent number?
6 and 7.
6 and 7.
6 and 7.
6 and 7 is the general manager and deputy general manager. Where is this IVRCL?
They have not appeared. They have not appeared because
Are they made a party?
Yes.
Where?
Is respondent number 6 and 7.
6 and 7, they are the general manager and deputy manager. They are not the IVRCL.
No, they have, lordship, they have consented. The main.
Have they
submission-
filed any affidavit? Have
No,
they
they have
appeared?
not filed, they have not filed.
You see, Mr. Counsel, this is the general manager and the deputy general manager. You have not made that IVRCL a party here. You have not made you have made the deputy manager and general manager. Supposing you have only made some persons working under them a party. You have not made them a party.
They have, yes, it is true. They have forwarded the bill, and as per forwarding the bill to Contractual, we have been paid. This is admitted. We have lawfully executed a work and we have been partly paid for this. And now it has been sanctioned. 13 lakh something was balanced. It, as per page 32, 5,86,993 has been sanctioned and directed to be released by the power grid. And as per the consent, now consent has been disputed. It is there, consent is also there.
No, just a minute. You are a subcontractor for IVRCL, correct?
Lordship.
Now, where is your contract agreement?
This is an admitted fact, Lordship. Contract agreement is not there. Ma'am, Lordship, page 15, may kindly come, Lordship. This is a power grid document.
No. So now this IVRCL, what work were they doing?
We have a transportation work,
Transportation work.
transportation
They are doing transport. They were given a contract
contract.
by the power grid,
Yes,
for transportation
Transportation.
of materials.
material,
And the IVRCL has subcontracted the work to you.
yes.
Now, how much work have you done?
Oh, entire work.
How much is the volume?
Total
37
lakh 28,049.
Huh?
37 lakh 28,049.
37 lakhs
28,049.
49.
49.
And then how much has been paid?
Paid first part 12 lakh 18,595, and then 11 lakh 970. 11 lakh 078. 97,078. 97,078.
11 lakh 97,078.
97,078. 078, yes. 078.
And what is the balance?
13 lakh 12,376.
13 lakhs 12,376. That is the balance.
Balance. Out of which 5 lakh 86,993 has been sanctioned and directed to be released.
5 lakhs
86,993.
993.
Now they have also admitted that at least 5 lakh 86,993 has to be paid. Only our consent letter from IVRCL is not there. Now this is not correct, Lordship. Page 35.
Yes.
It is by IVRCL to the power grid. Dear Sir Lordship, surplus tower parts transportation charges from A2 package to A3 packages. Details have been given below. For further releasing payments to Messrs Logistic Transport of India Private Limited for rupees 13 lakh 12,376, Lordship. And all this power grid noting is there. And on this basis, page 32, sanction was made by the power grid.
So this 13, 12, 370. Okay. So this letter is here.
They are lost.
This is to the general manager, power grid.
Power grid corporation.
So 13 has to be paid. Yes. So
Out
that's
of
it.
this, they have sanctioned 5 lakh. Now I am not claiming 13 lakh because 7 lakh 25,000 they did not sanction release. Now 5 lakh 87,993 it is sanctioned and released.
Yes. Yes. What is MOM? Huh? A memorandum of understanding, how can M be understanding? MOM means what? Please do not, please do not make up your own words. Okay, man.
Different part of states, the payment authorized by the main contractor of the contractor, the approval of the computer of when there is a sufficient amount relating to the contractor lying with power, here is a petition case is going on in between the power and method ID are limited. The different part of states as the applicant by the amount of which is 12 lakh, 95, helping last 97 has already been reached by far based on recommendation of members ID RTL, which appropriate of computer authority. But the amount of 55 lakh -93 cannot be purchased other issues against the application case. However, the amount of already paid, which is mentioned to the different things to be put any sort of so no different details happen to the we cannot make the payment without any
No, but he's relying on this document at page, what is that document you're
Page
relying?
32 loss.
32. 35, yes, page 35. He's relying on page 35. Now, what do you say about this page 35? What have you said about this page 35? Huh?
Earlier two payments. There is a 1 and 2 manner against what number, like 18 to 25 and 4 to 2025 existing manner. They have obtained a contract from the
Mr. Counsel, please understand the question. The question is, this page 35 is there.
Right.
Now, this page 35 amounts to an approval being given by IVRCL to you to give the money to them. If it is an approval, why are you not giving? Because you said that approval is not being given, but he's saying that this page 35 is an approval. If it's an approval, why are you not giving?
Lordship.
Transport of India, I bring into repeat, but in that case, doesn't matter, 376 matter. That's not the amount of this approval of getting money.
So he says this 13 lakh 12 contains this 5 lakhs 86,000.
Page 32 may kindly listen. Clear. After this IBRC letter, page 32. That's the sanction.
I think your issue is what is the arbitration case about between you and IVRCL? He did not complete. Okay, so if he did not complete, okay. But that is between you and them. How much is the bill otherwise? How will that arbitration case affect this case?
Because of that, they will be attached to any money in the additional property only money.
Then you say that just a minute. Whether they'll be entitled will depend upon the arbitration case. That's what you're saying. But the other argument you said was that unless that IVRCL gives approval, we cannot pay. They have given approval. So you please make up your mind, which is your stand? So you mean to say no approval was given for 12 lakhs 18,595? Huh?
Yes.
And then why did you pay if no approval was given? Yes, so was approval given for these two? Was approval given for these two amounts, 12 lakhs and this 11 lakhs?
Page 16 is the approval.
No. You're not making sense. Your argument is not making sense. Say that, that's a different issue. You are saying that unless approval is given by the principal contractor, you cannot pay. Now, approval has been given by the principal contractor. You cannot, now that argument goes.
Not just page 32, my lord. Page 32 of the last line, last line. The balance rate for logistic transport of the seven last 25,000 it can be revealed at a labor store out of the payable yields of method I believe. Clearly it is mentioned that if some amount is payable to the IBC, then only this amount should be paid.
So, he's claiming 5 lakhs something.
Right.
He's not even 7 lakhs.
Previous paragraph, Lordship. Only the previous paragraph. 5,87,993 has been sanctioned and should be released out of 13 lakh.
They have not produced the agreement. The agreement they have entered.
Mr. Council, don't change your stand as, don't change your stand. Going every step you're changing. Sometimes you're going this way, then suddenly you're going left, suddenly you're going right. Please make up your mind what you want to argue. You cannot say anything that comes to your mind. You have got to be consistent. Otherwise, we'll call your officer, let him explain. Because you're not making sense. I don't like to say it, but you're not being consistent in your submission. You please read the page 32, the second last paragraph. Second last.
However, as part our record, the card running the for people, the total amount of work are paid will be classified as per the document. Which is 41 lakh 60 members agency out of which a direct payment for an amount of 1 lakh 28,000 has already been made to members in the past running and to running now an amount of 1 lakh 7,200 will be get into the beginning of the party of your our part of that together. But of course, each by the first policy standpoint. Together the include for the door. Now the total balance of the work until after the deduction of the amount of 55 lakh 6,993. Now the amount they have proposed for direct payment it is present card revenue. These are 5 lakh 6,993. That has been approved.
That is the amount that he's claiming. Now the amount proposed for direct payment in this present third RA bill is 5 lakhs 80,000, 86,000. This is what he's claiming, that's all. And approval has been given by the principal employer, contractor. So how can you deny him this amount?
Only business part, the main part of the particular they have not been made a party member. That is for they have not appeared also.
That is not your case. That is not your case before us. That is because that came out from my mouth. You cannot make different submissions as the day goes on. By the time it's 1 o'clock, you'll have 20 other submissions. You've got to be consistent, Mr. Council. You cannot take up each and every stand that is there under the sun. Your basic case was, first of all, earlier that it has been paid. The order says, then we directed you to submit affidavit. Without submission also, you still said it has been paid. Then once you had filed your affidavit, it was found that you had not paid the amount. Now you took a stand that since the principal contractor has not given approval, you cannot pay him the amount. He just showed you the approval given by the principal contractor for paying the amount. And now you have changed your stand. Your stand is due to an arbitration proceeding between you and that IVRCL, the principal contractor, in which case that principal contractor might be required to pay some amount, you cannot pay him. Now you're changing your stand, mind you. Thereafter, we showed you page 32, second last paragraph, where you have agreed to pay 5,86,993. Now you're taking a stand that he's not made the principal contractor a party. You're changing your stand from here to here to here to here to here. Every step of the way. Is that not expected of a senior counsel at all? How can you change your stand like that as you go along, every day changing your stand? Not even it's not even your written affirmation. It's not even in your pleadings. How can you change your stand like this? You pay him the amount, that 5 lakh. How can you do this? Otherwise, we'll tell your officer to come.
It is the admitted amount, Lordship. This is not a disputed amount.
Whether they will be attached to any amount for execution of two of matter. Only arbitration, in the arbitration that will be decided.
So you please tell me, is the statement of claim made in your arbitration proceedings? What is your claim in the arbitration proceedings? Who has initiated the arbitration proceedings? They made. Statement of claim has been made by them. Now, what is your objection to it? Any written objection to it?
This is in the year 2019, Lordship. Arbitration was initiated 2018 or 19. And this is 2016 recommendations. 2016 recommendation admitted to be paid.
Huh?
In 2016.
Why is the arbitration proceeding not, is 2019 arbitration proceeding?
Yes, Lordship. After this,
But it's like a court case only.
we do not know about only on the
Arbitration proceeding has to be completed within how much period? Within a short period only. Huh? 1 month, 1 year.
1 year.
1 year. And 2019, why is it still pending here? I mean, before the arbitration. No, but then if they have done the work, then they've got to be paid. That's all.
And it is admitted. It is admitted. Had it been disputed, the question of arbitration, okay. But this 5,86,990 is disputed, admitted in the year.
But Mr. Counsel, there's one problem. You have not submitted all the documents. You have not submitted. You have not made them a party also.
They have.
You have not annexed anything. Now, I understand your case. But you see, when we pass an order, we have to ensure that everything is there, A, B, C, D. Otherwise, our order might not be proper.
Everything they have admitted, everything they have.
Mr. Counsel, please.
They have admitted that we are a subcontractor. They have admitted they have paid on 2 occasions direct payment. And how?
Please give me your contract agreement. Let me see what is the terms of the contract. Where is the termination of the contract of IVCRL?
We are not aware of that. Only they have filed affidavit.
They have not put this. I want to know the terms of your subcontract between you and that principal contractor. Where should the money go? Should it go to the bank of the principal contractor or should go to you? All that.
No, Lordship. Lordship may kindly come to page. They directly paid to us. Page 24. This is a bank statement.
You see, you bring your your contract agreement with that principal contract. I've got to know how is the terms of payment to be made.
It has been directly in the
I mean, you
approval
see,
letter.
just because they gave you directly, that's okay. But I don't know whether it's been done as per the terms of agreement. I've got to ensure that my order is proper. You might be 100% correct, but I need proof. If it's wrong, I might be passing an order which is not as per the contract agreement. I have to be careful that my order is proper. You bring the contract agreement.
Bring it.
Mr. No, you have got to pay. You have got to pay. That much I'm very sure. I'm very sure about that because page 32 and 35 and all, they are very clear. Only thing is that he has not given everything here. Because I want to be sure whether you are the contractor or not, subcontractor or not. There also nothing is here. It's only your statement. Where's the proof?
This is the documents of power grid, Lordship.
Correct. And then
These are documents of power grid. This is page 15 and page 30.
No, but I want to see. I've got to be careful. And then I want how the payment should be made. Whether it should go directly to your bank account or through their bank account or what, all those.
Previously, two payments are.
Maybe there can be a collusion also. I don't know.
Okay, I will bring it.
Mr.
SD Purkas.
S.D. Prakasa, learned counsel for the petitioner, shall produce the contract agreement made between the petitioner and the principal contractor. Full stop. The Mr. N.C. Das, learned senior counsel for the response number 2 to 5, shall also obtain instructions as to why the amount of rupees 5,86,993 is not being paid, despite the letter dated 29/7/2016 passed issued by the Chief Manager, Construction Imphal, Power Grid Corporation of India Limited, which is at page 32 of the petition. You have to pay. It's very clear. Nothing.
God bless you.
Huh? This is a matter after a week.
Item 17.
You're not giving the proper documents.
17.
Right. No one appears for the petition on call. The petitioner herein had been allowed to operate 13 number Nanoi Meen Mahal, District Nagaon, up to 2/12/2020. Full stop. Thereafter, no, as the petitioner's settlement of the fishery for 7 years was coming to an end, he submitted a representation for extension of the fishery for another period of 7 years. Full stop. The fishery department, while order dated 2/1/2021, extended the period of settlement of the fishery with the petitioner for another period of 1 year, with effect from 2/12/2020 to 2/12/2021. During the said period, the petitioner submitted further representations on 23/09/21 and 29/9/21. for extension of the fishery settlement for another period of 4 years. Ms. Udas, the counsel for the orders for submit that the writ petition appears to be has become infructuous. To subject on considering the absence of the petitioner, this court is of the view that the petitioner is not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution.
Item 90.
What to do? License is valid up to 22. Correct. No one appears for the petition on call. Ms. Udas, learned counsel for the respondents, submits that the matter pertains to allotment of a license to the petitioner under the Assam Public Distribution of Articles Order, 1982 on 6/2/2019, which had been extended from time to time till 31/3/2022. The grievance of the petitioner was that in spite of the license being valid, no PDS quantity had been allotted by the authority. As this court has also noticed that no one had appeared for the petitioner on the last date also. As the petitioner is absent for the second time consecutively, this court is of the view that the petitioner is not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution.
Time being 11.
What is to be done? Is there any alternative remedy?
Section 75, there is an appeal.
Section 75. Show me section 75.
Assam Value Added Tax Act.
He says that it is beyond time. Okay, anyway, give me that. Heard Mr. R. Dubey. No, give me that. Then counsel for the petitioner who submits. Where is the challenge to page 54?
Yes, my lord. There are challenge to the assessment order as well 54 is the notice.
Which are the
Page
documents?
45. Page 45.
Submits that. 14/11/22.
My lord, it's 49.
Huh?
49 is the assessment order. The type of. It's at the top, it's been dated, my lord. 22/11/2022. What has happened? My lord, the outer limit is 2016. Here up to 2016, they could made an assessment. In 2012, they had issued a notice. We represented, my lord, thereafter nothing was done. All of a sudden, my lord, your lordship sees that notice at page 14/11/2022 at page 45. This notice was issued to us, giving us time on 21/11. On that day, my lord, my representative appeared, my lord, and said that the the brother-in-law of the one of the partners has expired in Nagaon. He has gone there, and they subsequently we have also submitted our representation on November 26th at page 46. But in the meantime, without giving any adjournment, the assessing authority has passed that order, my lord. So that is purely without jurisdiction because the time period has elapsed, my lord. The Act says that
Okay, right. Let me start the bill and counsel for the petition. The petitioner has paid for setting aside the assessment order dated 22/11/22, comma, notice of demand dated 22/11/22,
and my lord, recovery proceedings, my lord. at
and the
page-
recovery proceedings initiated by way of certificate dated 7/9/2024, and notice of demand dated 7/9/2024. The petitioner's case is that the above assessment orders and notice of demand are time barred in terms of section 40(2)
Yes, ma'am.
of the Assam Value Added Tax Act 2003. In as much as the reassessment has been made after the expiry of 8 years from the end of the financial year. He also submits that there is an alternative remedy available in terms of section 75 of the Assam Value Added Tax Act, 2000. Mr. B. Chowdhury, Learned Counsel for the finance,
All the respondents.
for all the respondents. Submits that he will take obstructions instructions as to whether the assessment orders and notices are time bound. When is the matter on 18th?
Till then, my lord, your lordship will protect.
Nothing would happen.
Baki the notices have been issued. That's why we have come, my lord. They will take coercive measure. No coercive measure.
Right, no coercive action should be taken to the on the petitioner till then.
Keep your breath.
23.
As per order dated 28/8, so the additional deputy commissioner has filed an affidavit, lordship.
Ah,
Approach them to get the. I'm taking photography from today.
It is affidavit is filed on 13/11, lordship. I am suffering, lordship.
ah,
Submission. I actually do 3 months from morning itself.
ah,
Where I think before I have not. It is not like you. When you approach someone.
you give him a copy. Okay, so what to do? What do you want?
Lordship, as per the affidavit, lordship.
Oh, Monday.
Monday, lordship. Friday, lordship.
I asked for and I have already shown the instruction that you have directed me to
So now what is to be done as per that? No, then will have to be done. What is to be done now?
And
So what is to be done for the, if it's petitioner's land?
so
A settlement is for which period?
7 years.
And that'll end when?
Till lordship settlement was given in the year 2017,
Ah,
but possession was handed over in the 2021.
oh my God.
So then it goes to 28. So I
Ah,
am suffering. So my only prayer is not to allow the leasee to fish over the patta land of the petition. My limited prayer, Lord.
correct. Then that way the government will have to make remission of the
Yes.
of the amount payable by the lessee. That's all. You are the lessee.
I am on the basis of regulation 16 of the account
Ah, what?
that provides the declaration of society.
Ah,
Declared to be registered Fishery. Nobody can claim any right over the land.
no. I don't.
Affidavit is very clear, Lordship. This point has been argued earlier also. The
Ah.
fishery, the affidavit says that the course of the bill has been shifted to other because most of
Ah,
the part of the bill has been dried up.
You see, your submission is completely accepted. Only if only if it is government land or some other land, not private land.
But the affidavit says, this fishery was declared as notified prior to 1920 as a field fishery. And what is the stand of the government at this stage? Government is technical. The course of the field fishery stage, then is course of a stagnant water, this stage, that we are, unfortunately, we are accepting it. Because the Buguri courts cannot be said. It's a big.
Maybe their English was not good enough. Maybe they meant something else. Force cannot be changed.
Here the Becky River is there. The
Okay.
earlier
The Becky
affidavit-
River is there.
Yes,
Okay.
Lordship, the course of the
Here, why we are able to understand, it says, these fishery declared prior to 1920. There are 7 bills. Can the course of the bill change?
No. Course of bill cannot change.
Yes.
But if the bill is fed by a river system, then
Bill is
fed by a river.
no. That is not the kind of the bill. This is comment. Comment said that this bill fishery, epidemic case. I have to say.
Okay, so the bill can be demarcated.
yes,
You-
after demarcation, this affidavit has been filed, Lordship.
Okay,
This honorable.
but
court-
how is it demarcated? Is
in
underwater?
presence of both the parties.
Is it, huh? Okay, in present party, it was done. Okay, they were done. And they agreed also, they signed.
Yes.
We don't have the difficulty. What I am saying, we are going beyond the law.
I don't know.
This court can.
No, but,
What is the law? Once it is notified, it cannot be corrected by the deputy commissioner. Let go government. Then you are going to direct the government.
no, just tell me one thing. If your clients were part of that verification,
I don't know, I have no idea.
Earlier
Oh.
affidavit, so Lordship, how he can say,
so
But his
you
client
have
is
to
not
bring the records then, madam. Unless you bring the records. So just a minute, Mr. Counsel, one at a time. Let me talk also. I'm only hearing you all whole day. Yes, so please let me ask some questions and to her. So the issue is that unless you bring the records, we do not know whether verification had taken place and who was part of the verification. How was it done? Did they go with the scuba gear underwater and measure? Oh, what was it? So we have to check all that. It'll take some time, I think. But Friday will not be possible. I think you are going to argue quite a lot. The way he's going, he's going to come hammer and talk that it.
Lordship, my learned friend is arguing that bill was settled in the year, demarcated in year 21. So therefore, our patta land has been given in that bill. If that be so, why he has not challenged our patta till that?
No, he knew it only now.
Not now, it's a dispute going on. Because
Since when?
though the
Dispute,
settlement was
dispute going on since when?
2017,
This writ petition is of 23.
23, because settlement was made in 2017, due to these issues, could not be handed over till 2021.
Anyway, we'll take it up again some other day.
Okay.
Now though it's winter time also.
It's a admitted case, Lordship. The settling authority has filed this affidavit, none other than additional.
No, but then you see, he has brought out a legal point
Yes.
that the bill,
Yes.
the character of a bill
Yes.
cannot be changed by
Lordship, kindly
DC.
come to
It can be done only by the government.
kindly come to the paragraph order dated 8/1/2024. He made that argument on that day also.
Okay.
Considering this order has been
8/1/24.
Yes, Lordship.
8/1/24. Yes.
Married, Lordship.
Yes.
Hatsiri as the learned counsel for a petition.
No, go to the operative portion. Don't go to everything. Huh?
Accordingly, the Deputy Commissioner Barpeta is directed to cause an inquiry, especially with regard to the area in question as to whether the lands covered under the aforesaid patta numbers are within the notified boundaries of the fishery in question. The said inquiry is to be done strictly in accordance with the law and by giving a scope of hearing to all the stakeholders whereby they would be in a position to furnish all relevant document. What remains, Lordship? After that, the additional Deputy Commissioner Fishery has filed his affidavit.
Prior to the date of online, there is a register of fishery law.
Yes.
Why register of fishery? The entire.
Lordship, then Lordship come to.
Okay, the fish, it's only to verify whether the fishery is within the petitioner's land or not.
Lordship come.
That was the direction, but that direction was not.
Earlier, what happened? How did it become part of the bill? Or because the flood waters were there or what? Or was it earlier it was above the water level, now it's below the water level? How? What happened?
Because now the most of the bill area has been dried up. So this land petitioner's land is also a low-lying land. So therefore, the government, while handing over the bill to the leasee, circle officer handed over the patta land. So this is our grievance.
So during winter time,
Yes,
the land will be arable land,
yes,
and during monsoon time, it will be a
bill.
So you share it. Let him look after it during the rainy season, and you look after it during the winter season.
Lordship kindly come to Lordship's last order at the 28/8. That argument on that day also met.
Okay.
Paragraph 4, Lordship, paragraph number 4. The
Yes.
counsel for the respondent number 6, on the other hand, submit that the report dated so issued by the circle officer does not indicate as to whether the circle officer had made the report of Bolaikuti bill after comparing his report with the register of fisheries, which kept in the Deputy Commissioner's office. The report also does not indicate as to under which bill the land of the petitioner has been found, inasmuch as Bolaikuti bill comprised 7 bill, which is a group fishery. So in compliance of this order, this affidavit has been filed by the additional Deputy Commissioner Fishery, stating that some of the patta land of the petitioner are now using by the respondent number 6. So what remains, Lordship?
They're using it as what? For
fishing. Fishing, Lordship.
So it's still underwater.
Yes.
So it's still underwater.
What remains, Lordship?
No, is it all? Has it always been underwater or what?
Because low-lying land, Lordship, we are also using that.
No. So how did they give patta on a land that is always covered by water?
Because we are also using this as a fishery.
But they can give you as a fishery, they cannot give you as a, for.
Sometimes agriculture is also done, and sometimes fishing is also done. A part of that land is our residential, and then a part is for agriculture and the fishery. Photographs is also real also.
Do I have the photo here? No. You make not only for yourself, ma'am, for all others.
Otherwise, Lordship may direct the Deputy Commissioner to consider our representation that is pending before him. Matter may be disposed of, Lordship. He will look into all the matters. Which is the patta land, which is the fishery land, he will be decide, Lordship. That will be better position instead of keep pending this for one and after.
Naturally, in accordance with law.
In
but,
accordance with law.
It is basically, you see, the issue is basically this, whether they can differentiate between the bill land and the thing. If it does not, as long as it doesn't overlap each other.
Then I may be allowed to be within the boundary. These are, so we have the lease agreement with the deputy commissioner. There are some boundaries they given there. Then measurement of that is there, 4,000 something. That land, I am entitled to receive. In below other section 16 of the other land payment. My prayer is limited to that. I have been given a place within the boundary.
I don't think DC will able to do it if it will have
It's
to.
better to government is the different department.
No, this court will decide it.
No, because government can modify now.
The other petition is filed.
Government is the. To modify the boundary.
No, but one thing is that if the boundary had mistakenly included the petitioner's land,
That is the issue,
then
Lordship.
if it had mistakenly included, then that boundary will have to go.
Because I submit because it's the connect the property. There they got the closure the year 1957. And my sister, it was declared in 1905 to 1920. Now the tax, your lordship will.
No, the only issue is whether there is encroachment, overlapping of the land, that's all.
To the bill or not.
Whether there is
That is the
overlapping,
issue.
that's all. So that is the only thing. There's not a question of changing the boundaries. Boundaries cannot be changed.
Boundaries cannot be
The only
changed,
thing is that whether there is any overlapping of the fishery and with his land. That's all.
As per this, you know.
Whatever. So if there is overlapping, then you have a case. If there is no overlapping, then he has a case.
Lordship, may,
So now who is going to decide whether there is overlapping or not?
that has been reviewed by the
No,
Deputy
no,
Commissioner.
please answer the question. Whether there is overlapping of lands, whether there is overlapping of fishery with his land can be decided by whom? Don't say government, please, because government is only, please, who is going to, which authority is going to do that?
Deputy Commissioner in consultation with the
With-
fishery
with-
register.
Fishery and maybe the circle officer or something like that.
Nobody is under the.
Correct, but Mr. Council, but his pass was given not by the fishery department. His pass, please understand, his land pass is not given by the fishery department. That's clear. His land pass has been given by whom? Land documents are given by whom? No, which officer in the, in which office does it? Yeah, record of deputy commissioner. That means the circle officer, they are the lowest. You don't expect the deputy commissioner to go and do all your measurement. Who does it? Let us be clear, who does it? Who does all these measurements? Mandal. And Mandal works under whom? Mandal works under whom? Circle officer. Circle officer works under the DC. So it's under the DC's establishment who will decide. The DC and the fishery department, they can take a decision as to whether his land and your fishery overlap each other. Once they take a decision, then if they find that there is overlapping, then you have a case.
Yeah.
If there is no overlapping, he has a case. That's all.
That is all.
What is to be decided?
Overlapping is there.
Correct. Only, that's all.
With that observation, it.
Overlapping of your fishery area with his land. That's all.
Literally, I am not. Even today, I am also coming. I'm not interested at all in that. This Pakistan.
Correct, correct.
Right. Now, one thing is that, suppose, what, if you are from his own record, the record was, disclosed the 67, what I submit, and my return is 1921 declared. So, any land, if they included in the fishery, then that's the outlet.
Correct, correct. That's the truth. That's true. That's what I'm saying. If there is overlapping of the area of the fishery with the land of the petitioner, then you will have a case because your fishery was declared fishery in 1920. So you, but if there is no overlapping, then he will have thing. Now that can occur. That can occur if there is a mistake committed by the authorities now in settling the fishery by including his land. So if there is a decision made, whether this is supposing the decision is to the effect that there is no overlapping. However, the area of the fishery that has been settled with you overlaps his land, then the fishery will have to correct its mistake and maybe make a remission as to the amount of revenue payable by him. That's all.
4,198 figure of, sorry. It is the on record figure. It is on record figure.
4,098
198 figure
bigas of fishery.
of the.
As per the 1920, as per 1920, what registration what?
Because it has to be declared under section 16 of the Assam Land and Regular. Declared.
Section 16 of the
It is of the Assam Land and Revenue Regulation. Section 16.
of the 1886 Assam regulation. Okay, and his land was issued on the basis of which
There are
law?
patta number 384, 387,
384, 387,
349,
349,
358,
358,
500,
500,
and 30.
500,
And 30.
30 separate. No, 530.
30 separate.
500
500
is different and
different
30,
and then 30.
30 separate.
30.
So
It-
your pata numbers
Yes,
which are included in the fishery
yes.
is 384, 387, 349, 359, 530.
Yes.
In terms of what? In terms of verification made by whom?
In terms of, that is our claim, but affidavit shows the
What does the verification report show?
verification in the patta number is not mentioned, DAG number is mentioned. Same patta, under the patta there are different
DAGs.
DAG
Okay.
number has been mentioned.
Okay. DAG number?
379,
DAG number 379, 380,
777,
777,
428,
428, 443, 444, 522, 521, 580, 581, 582, 583, 584 of village.
only in respect of Palgasya, because
Okay.
petitioner claim is in respect of Palgasya.
Now, these DAG numbers pertain to which patas?
Three 384, these are the patta.
384?
Earlier I have given 384, 387.
No, but then these dark numbers
Yes.
cover which patas
Then Lordship,
or under which patas?
then Lordship have to come, last order dated 28. Lordship. Here is the mention, Lordship. Because all ducks are not under this fishery. Some of the ducks.
No, I am only interested in the dogs which
Yes,
are,
that-
which come
that is
under the
mentioned.
fishery.
That is mentioned in the last order date 28, 2020.
Okay. Out here. Just a minute. 584. 625 is not here.
65 in the last, in the earlier affidavit stated that is we included the bill, but last affidavit says that
It's not there.
not yet.
Then 349 pata number is there. 368 is not here.
368 not here.
777 is there.
777 is there.
Then 358.
379.
358 is not there in this now in the period pata PP. 358 is not there.
358 there, Lordship. In our-
359 is there now. You said
No,
you said
358,
Patan-
358 patta is there, Lordship.
in the last affidavit it was there.
370.
The report submitted by an affidavit of 24/5. Because in that report, circular report, may I read it? And it is true that today the water would be covered periodic pattal and covering number 379, 380, 381, lot of which now they say it is data. This is the report below which connects with the code. In the affidavit. The lot number and pattal number changing after one after another.
That's a record.
Lordship, Lordship, best way it will be happy.
Huh?
Because we have mentioned that we are the owner of this pattalan. So whether this pattalan has been overlapping with the fishery or not, that has to be determined. This,
No, the problem is, I thought I will attempt this case. The problem is now the reports, the two reports are also different from each other.
yes, Lordship, in the,
So now we cannot, so nothing can be said with certainty.
yes, Lordship.
So the only issue now is maybe we have a, please listen now. Maybe we can ask the fishery department and the DC's office to have a joint verification with regard to whether your land
Yes.
is included within the fishery land. Okay. Now, if they say that your land is included within the fishery land, but the area does not, if they say included within the fishery land, then the problem arises.
Yes.
The problem is now whether whether the fishery land, fishery area is better if fishery area, whether it overlaps your land.
Yes.
is that. If fishery area overlaps your land, then you have got a problem. You have got a
Whether
problem
my
because the
patta-
fishery was 1920.
Yes.
But if the fishery area
Yes.
does not overlap your land,
Yes.
though it might be a part of the fishery, but it does not overlap your land,
Yes.
that means they have given more fishery area to you than should have been given.
Yes.
Then you have got a case. That's the only way out. So that's why they have to have a joint verification done. Because fishery is by the fishery department, his pass is as by the DC's office. So and these are the two departments who has to settle this.
Yes.
That's the only way out. Otherwise, what can be done?
All Lordship direct the deputy commissioner to pass a speaking order on our representation
after going through the fishery records, whether my,
That can be done also.
that can be done.
And he can also, he can
put the parties-
can also hear the,
Both the
he
parties-
can also hear the fishery department. No, both the parties, also the fishery department also.
Also fishery department.
That has to be also heard. Otherwise, this is a question of fact.
Yes, sir, that has to be determined by the authority in accordance with the law, whether that is included in the fishery
We
or not.
thought we can decide if the reports come.
Yes.
Problem is, two reports have come and there's slight change.
Yes.
That's the problem. So, nothing can be decided with certainty.
So direct the deputy commissioner.
So you don't want that order? Her affidavit, no need.
That's right, that's why I stayed for it. He relied on the epidemic filed by.
So, report,
I got, we have written a lot, I think, on this issue. Heard Mr.
Yes, sir.
S. Dekal, counsel for the petitioner. Also heard Ms. U. Das for all the state respondents. 1 to response number 1 to 5. Mr. Yes, you appear for whom? Respond number 6. That's all. Full stop. Okay. As well as the petitioner in WPC number 2172 of 2020. Acha, Ms. Ludas, we won't say responsible. We'll say the for all the state respondents. For the state. Better that way. There's no private respondents in your case, right? These two writ petitions are being taken up together for disposal in view of the fact that the subject matter in issue involved is intertwined with each other. Full stop. Next paragraph. The dispute no, the issue in WPC 2056/2023 is that the land of the petitioners covered by KP Pata number 384, 387, 349, 358, 530 of Revenue Village, Kalgachia, Muza Rupsi, Revenue Circle, Kalgachia, District Barpeta, Assam, has been included in the Balasuti Beel fishery, which has been settled with the respondent number 6 for a period of 7 years. Pushpa. The petitioner's case in WPC 2056/2023 is that the is that a direction should be issued not to allow the respondent number 6 to carry out fishing activities over the land of the petitioners. Pushpa. Next para. The case of the respondent number 6 in WPC 2056/2023 and no, comma, who is also the petitioner in WPC 2172 of 2021. Is that the petitioner was settled with the Balai Suti Bill Fishery for a period of 7 years. The circle officer, Kalgachias Revenue Circle, wide letter dated 29/1/2021, directed the respondent number 6 to appear for a hearing regarding a complaint received by him with regard to the fishing activity being undertaken by the respondent number 6. While the letter dated 29/1/2021, the petitioner was directed not to continue his fishing activity. Thus, a challenge was made to the said restraining order in WPC 2176 of 2172 of 2021. Next para. The issue, as can be seen from the above. Now, the issue that has to be decided is as to whether the fishery that has been settled with the respondent number 6 covers the lands of the petitioner. Puspa. The Balai Sati Bill Fishery was registered with the Register of Fisheries, with the Registrar of Fisheries, was registered with the Registrar of Fisheries in the year 1920 with an area of 4198 bigas. Correct? Is that correct? Is that disputed? Is that correct or disputed?
Not in my tender notice is there.
Okay, just see. I don't want you all to later say that it's. No, show him also.
Kuntu.
Don't be too close, very from far away you show him, otherwise
Oh,
it's okay.
$4,000
4198
190.
1920. Okay, first time. On the other hand, the patas that were issued to the petitioners had been issued in the year 1967 onward. First time. Though next para, though the during the proceedings of this case, the Deputy Commissioner Barpita had been directed to cause an inquiry with regard to the lands covered by the petitioners patas. And as to whether the said lands were were within the notified boundaries of the fishery in question. So, sir. How many reports have been, where's the two reports? Where's the two reports? Page 139. And the second report?
Second,
The first report with regard to the above direction had been made on
2/5/2020.
2/5/24. While the second report was made on,
Affidavit was filed on 13/11.
no, where is it?
Report not enough.
Let me see the report, second report. 22/10/2024. 20. Do I have it? I don't have. Okay, right. Give me that. I want that. Next para. The report dated 2/5/2024 has been issued by the Circle Officer, Calgachia Revenue Circle, and addressed to the Additional Deputy Commissioner bracket Fishery, Barbita, which states as follows. Page 139, you take from here to here. Okay. Next para. The second report dated 22/10/2024 has been issued by the Circle Officer, Calgachia Revenue Circle, and addressed to the Deputy Commissioner, District Commissioner Barbita, which is as follows. Out here in pencil again. Second, the page 403. So there's slight difference, no? In the is there? Not this. So there are three reports. Yes, correct. What have I said? Okay. No, don't say that. To cut all that, just say, cut that last paragraph. Say how many two reports I said, no, just prior to that, whatever I said. And three reports actually, it'll be three reports. So the third report was made by the additional, no, was made on 8/11/2024 by the Circle Officer, Calcutta Revenue Circle, to the District Commissioner Barpika. Next paragraph. On considering the fact that the matter pertains to disputed questions of fact which would require, which cannot be decided in a writ proceeding, comma. This court is of the view that the district commissioner, Barpita, should be directed to, should make a verification with regard to the claims of the petitioner and the respondent number 6 as to whether the area of the fishery overlaps the land of the petitioners. Full stop. Next para. The councils,
Or lordship, the petitioner's land is included in the notified boundary of the fishery or
no, that is, I'm going to put that. You just hear me out. Wherever correction needs to be made, we'll make it. The counsels for the petitioner, the respondent, the respondent number 6 and the state government submit that they consent to the proposal made by the court that the issues raised by that the grievances of the petitioner and the respondent number 6 should be decided by the district commissioner Barpita. After, no, that's all. Next, accordingly, on the consent of the parties, comma, this court directs. This court directs the deputy commissioner to cause an inquiry as to whether the land of the petitioner falls within the notified boundaries of the fishery. First up. If the land of the petitioner is found to fall within the notified boundaries of the fishery, comma, the boundary of the fishery, the area of the fishery will supersede. Now, do I have to say that? No. Ah. No, that's why. No, I said, if it does not fall, if it falls within, then the fishery will, the fishery area will supersede the area of the, that's what I'm trying to say.
Yeah.
If it's if the fishery, the area of the fish, the area of the fishery will supersede the area of the petitioner's patas to the extent that the petitioner's lands falls within the notified areas of the fishery.
And if not lordship,
Full
then-
stop. If the lands of the petitioners do not fall within the notified boundaries of the fishery, comma, the petitioner, the respondent number 6 shall not undertake any fishing activity or any other activity on the lands of the petitioners. Full stop. In that event, the fishery department may also have to consider the case of the respondent number 6 regarding the no need. Cut that. That might be too much.
an entire exercise has been done in
Next.
presence of both the parties.
The entire, the deputy commissioner shall cause the inquiry to be completed within a period of, it takes some time.
1 month,
No.
2 months. It's enough, lordship. Yeah.
No, this is
The drive years start already.
3 months.
Within 3 months, okay, within a period of 3 months from the date after giving an opportunity of hearing
To both the parties.
to the petitioner and the respondent, to the petitioner, comma, respondent number 6 and the fishery department. the, the decision taken should thereafter be communicated to the petitioner. That's all. Okay. Okay, the other one is already there. Just say the report dated 8/11/2024. No, report dated 22/10/2024 and 8/11/2024 issued by the Circle Officer Kalgaches Revenue Circle is made a part of the record and marked as Annexure X and Y respectively. Annexure Y.
Public.
Again, 2% royalty.
Yes.
Item number 10. Item, actually, out here, wait, we'll have to mention the land, no? So we just give a dictation. Otherwise, the steno is different now. Yes, what is your land? Where's your land pass number?
My lord, this is page number 29. The GMC, my lord, file number, under the file number of GMC, my lord.
No, Mr. Counsel,
Yes, my lord.
your land, you're planning to build a building on your land.
Is it private land?
Private land covered by pata number, dag number, where?
Yes. Lord, I have not annexed the land
No,
document.
you have got to annex.
I
Sorry.
have annexed the GMDA, my lord.
No.
The GMC.
You show me somewhere show me where this GMDA and GMC document pertains to
Yes, sir.
some pata land. Where does it?
Pata land is not mentioned, my lord. In the
Then how do we know that's your land?
GMC document.
Where is the proof that's your land? You've got to give the particulars of your land. You've got to prove that's your land. Your entire writ petition will go.
Lord, I will file an additional affidavit, my lord. The annexing the land documents
You can do that.
next week.
Right, Mr. M.J. Kadir, learned counsel for the petitioner, shall produce the pata number and dag number of the land which he claims is his own land on which he intends to build a building and for which 2% royalty has been demanded by the GMC, by the GMDA or GMC?
GMC, lord.
By GMC.
I will file an additional affidavit, my lord, annexing the document.
Yes.
Okay.
So what have I said? Which he claimed. The land particulars should be submitted along with a copy of the land certificate slash Jamabandi in the by way of an additional affidavit.
All right.
25.
Item?
Like application. The mere application. The motion to the books. Right, communication is one. Once every topic.
Okay, then in this case, what has happened?
Then pending similar speaking on the page 43 page of the similar application. Not as per this form below,
Page 43.
page 143. That's it.
So he has not submitted that 1 lakh also or what? No. Right. No one appears for the petition on call. The petitioner has put to challenge the order dated 6/2/23 issued by, no, has put to challenge the, no, has put to, where is the order? Has put to challenge the speaking order dated 14/3/2023 issued by the Principal Chief Conservator of Forest and Head of Forest Force Assam. By which the petitioner's application for a renewal of lease period of Borgang Sand, BORGANG Sand and Gravel Mahal number 4 under Sonitpur East Division, Biswanath Charyali was rejected. In terms of Rule 19 of the AMMC rules, 2030. The application was rejected on the ground that the petitioner had not submitted his renewal petition in the prescribed form MC-2 along with different details, and also due to non-submission of non-refundable renewal minimum, non-refundable renewal fee of rupees 10 lakh, 1 lakh minimum. The Mr. R. Gogoi, the learned standing counsel for his department, submits that this court, while order dated 11/11/24 passed in 3233/2023, had dismissed a similar case on the ground that the petitioner's application therein, which had been dismissed due to non-submission of the application in form MC-2, besides non-submission of minimum fee of rupees 1 lakh, what do I said? Yeah, Pustam. On that. He submits that as the present case is a similar case, it is a covered case, the writ petition should be dismissed. Next one. What to do? He's not here also. But there's no case. That's why. Yeah, what happened? Then,
They have to submit the renewal form.
that's why they've done this. I know. Next, on perusing the contents of the writ petition and the order dated 11/11/2024 passed in WPC 3233/2023. It appears that the present case is similar to the case in WPC 3233/2020. Next paragraph. However, as the writ petition is absent, it appears that the petitioner is not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution. Let him come, then we'll see.
26.
Okay, Lordship. Lordship, non-payment of Lordship, bill Lordship, admitted Lordship. Lordship. Page 12, Lordship.
Yes,
Total amount was 1,69,060 Lordship. Out of that Lordship, 84,000 Lordship. Paid Lordship. The remaining Lordship is 79,600.
yes, Mr. Gogoi. And the very little, this one, 79,677. Heard Mr. B. Malakar, learned counsel for the petition. Also heard Mr. B. Gogoi, learned counsel for the PWD, and Mr. J. Handik for this point number 3. Miss U. Das appears for this point number 1. Mr. Roy, you're there? No. Okay, right. The petitioner's case is that the petitioner had done works of maintenance and improvement of Binodini to Shibari Road, Karimganj district, for a total value of rupees 1,69,060. Though the petitioner has been paid rupees 84,000, how is the balance amount this? Mr. Counsel, please add 84,000 with 796,767.
There was a deduction Lordship.
Oh,
Please,
5,000. Yeah. But still, how does it come? Even if 5,000 was deducted, how does 677 come into play? I don't know how do you have this figure? Just add. You know, your mathematics is really bad. How do you- Let me see. Let me see.
page 12 Lordship.
Okay, whatever I said. However, though the petitioner has been paid rupees 84,000 and some deductions were made by the authorities, the balance amount of rupees 79,677 has not been paid. The petitioner's counsel submits that as per the memorandum of payment, what is this?
Memorandum of payments.
As per the memorandum of payment made by the accounts officer PWD, Rural Road, Karimganj Division, which has been forwarded by the executive engineer PWD Karimganj Rural Road Division to the empowered officer, ASRB, and chief engineer PWD bracket roads, while letter dated 28/6/2017. While letter number A-10/ASRB/1011. It is a forwarding letter.
Regarding the connector one.
Is the bank authorization letter.
Oh,
Memorandum is a separate.
okay. Don't say that. Then you just say why the memorandum of payments, huh? Issued, made by the accounts officer PWD, Rural Roads, Karimganj Division, and checked by the executive engineer, PWD Road Rural Division, Rural Road Division, Karimganj, page 12, huh? The petitioner is to be paid rupees 79,677. Mr. B. Gogoi submits that. The writ petition can be disposed of if a direction is issued to the
4 and 5.
respondents number 4 and 5 to verify the claim of the petition and pay the same if it is found to be correct. The counsels for the other respondents also echo the submission made by Mr. B. Gogoi. Learned counsel for the PWD. Next para. In view of the submissions made by the counsel for the parties, the respondents number 4 and 5 are directed to verify the claim of the petitioner and pay the petitioner the admitted amount. The verification and payment of the admitted amount should be made within a period of within a period of 3 months. 3 months, but no, but let me by March. But now December. In 3 months from the date of receipt of a copy of this order, the writ petition is accordingly disposed of. And there's another matter, no, same thing. Hmm? Huh? What has to be paid?
23,56,787.
93 lakhs.
23.
23 lakhs.
20 lakhs, 2,000. But, personal rent and money, acquisition person can of 2 lakhs something, 2 lakhs. So, it might that today.
So 20 lakhs has to be paid.
Already paid.
20 already paid. So how much is still to be paid?
Around 2,80,720 rupees. madam.
Equal to 2 lakhs.
618.
Yeah.
That is security deposit and EMD. So only this portion, only this. Is it correct?
Madam,
2,35,618.
madam, as per my calculation, madam, it should be 2,80,720. madam.
Have you got this?
No, madam. I have received just now from him, madam.
Okay.
I have to take some
So
instruction.
let him pay. So when will you pay this? What is that?
First time it was listed in
23.
second time it was listed.
So this 20 lakhs, 2,000 has been paid. Correct?
He is my instructor. After 40
Okay, Mr. Udas
Udas.
appears for the petition. Mr. S.K. Medi submits that as per the instructions received by him, rupees 20,02,755 has been paid to the petitioner. And the balance amount of rupees 2,35,618 is being processed for payment. He submits that the unpaid amount pertains to security deposit and earnest money deposit. List the matter on when.
31.
31.
The matter regarding, my lord, establishment of a new market. In this case, my lord, the local public of my lord Buthusar area, they my lord hold a meeting and they feel need a my lord daily market. Accordingly, they my lord applied before the my lord local MLA. Local MLA requested the my lord CB executive officer of the Golpar Jilla Parishad and the my lord district commission.
So they opened the new market.
They opened accordingly, my
So
lord.
that was cancelled
That was cancelled.
by the DC.
Not, it is my lord by the my lord district development commission.
Who is the District Development Commissioner of the PNRD?
No, my lord, under the my lord DC, he is not the DC. DC is the my lord district commissioner. Under his my lord earlier my lord, it was my the Asian district commissioner or the additional district commissioner. Now my lord the district development commissioner is created. So my lord, my lord, his term he has already expired, my lord.
Term is expired.
Their term has expired, they cannot object, my lord, because it is initiated by the Anchalik Panchayat.
This is again District Golpara Court so parties are Arkita Parbian. Who is this?
Is the response number 5, my lord. At the time, my lord,
Versus Shahabuddin Sheikh. Who is Shahabuddin Sheikh? Yes, who is the Shahabuddin Sheikh?
What?
Who was operating? What? Which 2%? What do you mean that 2%? What kind of a submission is this? Say that 2%. We don't know. Defendant number 1 and 2, there's no defendant, no parties here. Parties are not shown, all the parties not shown. Now, what is your concern with this writ petition? If your term has expired, huh?
30 June 2024.
So,
No, my lord.
No, that has been cancelled.
Lawsuit already held, my lord.
that 29/6/24 has been set aside.
Set aside.
Has been set aside by this court.
My lord.
Gone, finish.
And the
That earlier, let's say you have got no more right. Order of High Court is there. Order of Civil Court cannot override order of High Court. Which daily market has been restrained?
No, it is not the weekly market.
Huh?
It is not concerned with the weekly market.
They're not concerned with the weekly market. They're concerned with the. Just a minute. They are concerned with the daily market,
Daily
not
market.
weekly market.
So
So this case does not cover. This order does not cover their case.
Daily market.
No, Mr. Counsel, there's a difference between daily market and weekly market. This civil court order pertains to in page 6 of the writ petition. Yes. Huh? Yes. Page 64. Mr. Council, there is no page 64. Page 64 here is this. I do not know what is your locus standi also to make a submission. You have got no right. You have got nothing to do in this petition now. Your term has expired. The basis on which you are trying to make a stand that that notification of 29/6/24 has been set aside by this court. And the order there is that it should be run by the Panchayat, not by the erstwhile list settlement holder. So you have got no right. You have got nothing to say. I'm listening to you just out of courtesy. No right flows from any submission that you make. Then you can just take a seat. This does not. This is for the weekly market, and this pertains to daily market. No, Mr. Counsel, I've done enough. I have done enough of the cases here, which shows that there are weekly markets of the same name, daily markets of the same name, cattle markets of the same name. So please do not try to take this court for a ride. Because if you're trying to take court for a ride, we can also react. Okay, so please do not do that. If you want, you can help the court in trying to come to a solution, but don't try to take a court for a ride. Don't try to bluff the court, saying that they cannot be a daily mark. What do you mean? I've done so many cases. There's so many. I can give you so many NITs. I can show you. I can call for the records now. Today's case also I'll show you. Same Anchalik Panchayat giving same name. Only difference was in one it was for daily, in one it was for weekly, in one it was for cattle. So don't say that, don't think that there can be only one weekly market or there can be only one daily market. Not at all. Yes. You sit down. You sit down. I've heard you.
And my submission before lordship, my lord, lordship may correct down to page 53.
No, what is your case? Page 58. This paragraph 3. Paragraph 5 is page 60.
59.
Do I have to correct my records according to your thing? Wait, affidavit of?
2.
The point number 2. It's affidavit, it starts at page 65. Ranjit Konwar. This one starts at page 65. Okay, yeah, it has 2 pagination. One is probably your pagination and one is probably the registry's pagination.
Our 62.
Affidavit, no, affidavit in reply starts from page
62.
Starts from 62 and there is 69 also. There are two. Yes. Okay, para 5. That with regard to the statements. Okay, there is the one question is, can people form their own markets?
No, no, no.
Hmm?
No, my lord. It should be by the, my lord, Anchalik Panchayat. Initiated by the Anchalik Panchayat, that it should be, my lord, approved by the Jila Parishad. And the land should be acquired by the, my lord, district commissioner with the, my lord, the.
So your market has it followed that procedure?
My lord, it was initiated. There was some, my lord, irregularities. My lord. It is admitted fact, my lord, because Rashmi Kali Tandu pays, my lord, first, my lord, page 32. It was the, my lord, chief executive officer go to the Anchalik Panchayat president and the executive officer, page 32.
Yes.
32. With reference to the subject above, I am enclosing here with a public meeting along with recommendation letter from the MLA so regarding opening of a daily market in the bank of Budusar River. You are requested to consider opening of the said market in the interest of local public in the current year itself after adjourning the feasibility and observing necessary formalities as laid down under the Assam Panchayat Act and report and relevant rules. The market may be continued in the coming years also if found useful for our own source of revenue. It was from the chief executive officer to the BTO and the president. Then the meeting was held. That is where page 35 million on 5/1/2024.
No. You see, maybe the meeting was held. Meeting was held by whom?
By the Anchalik Panchayat meeting. It was the meeting of the Anchalik Panchayat. Translated copy at page 35 and the operative original copy at page 41 million. Assamese version, মাটি আঞ্চলিক পঞ্চায়েত সাধারণ স্থায়ী সভা সভা। No. How president? You had উপস্থিত at least no, it is something. It is sir. All the 6 persons, including the local MLA, out of 10.
Now this Anchalik Panchayat meeting has to be approved by anybody?
By the
Zila Parishad.
Jila Parishad, that's yes.
So where is the approval?
There is no approval.
Then?
It was the so my submission people lost in my lord. The page 53. It was my lord the district development officer commissioner passed the water improvement order, and he inquired the matter.
Huh?
He himself inquired the matter.
Ah.
Inquiry was called. Lost in kindly my letter see the matter. Whereas an inquiry has been initiated into the allegation by so and so on the matter of the functioning of Budusar daily market and Budusar Jaljali daily market. It is the new market.
So who is this MLA? So this MLA has initiated the inquiry against you.
No. It is their version, my lord, but we approve the MLA.
So according to you, the MLA is supporting your case.
We file an application before.
Please answer the question.
Yes, madam.
So the MLA is supporting the opening up
Yes,
of a
madam.
private market.
Yes, madam. Not
But
private market, madam.
Whatever that market.
New market.
Now, but in this letter, page 53,
My lord.
this complaint has been initiated by the same MLA.
But
It appears, correct, it appears.
Well, it
As-
appears.
That's what it appears.
Hmm.
So now we have to see whether the MLA decide or decide.
No, madam.
Or,
Whereas the district development commissioner Golpara has been interested to inquire into the matter. Whereas the district development commissioner Golpara has submitted his report to the district commissioner Golpara and the following facts has been observed. That the facts are observed and the main grounds is that the petitioner, who is the secretary of the market committee to run the new market, he was not submitted the minutes of the meeting before the inquiry. As paragraph 4 million. The new Budusar Jaljali market has been opened after a public meeting decision attending by MLA Golpar Sonso as deposed by Hazrat Ali, the secretary of the Budusar Jaljali market.
but he could not produce any.
Yes, but I have annexed in the repetition. So my submission before Lordship, my lord, let the district commissioner, my lord, to reconsider because, my lord, that order.
Even the district development commissioner.
Yes, my lord. Because he cannot, because, my lord.
No, but prior to that, won't the Zilla Parishad have to consider or what?
Yes, my lord.
Huh? The procedure is as the, why should it go to the district development commissioner? Let the Zilla Parishad consider.
Because my lord, already your lordship observed me the page 32 order.
No, I want to see the law. Show me the law.
Yes, ma'am.
How does for the formation of a new, for the opening up of a new market,
My lord.
what is the procedure to be followed? Show me.
It is page, my lord.
Yes, Brian.
One second. One second. Section 49 million,
Page
61. It is the general functions of the Anchalik Panchayat. Yes. New.
same book.
Section 49 million.
Yes.
General functions of the Anchalik Panchayat, my lord. And lordship may kindly, my lord, come to, my lord, subsection, my lord, 18.
Page.
Page, my lord, my book is 64. Market and fairs regulation. Market
and fairs, yes.
my lord, regulation of markets, fairs, and festivals. They can, my lord, regulate. Then, my lord, lordship may kindly, my lord, come to section 50. General powers of the Anchalik Panchayat. The Anchalik Panchayat shall have powers to do all the necessary for acts necessary for or incidental to the carrying out of the function entrusted or delegated to it, and in particular and without prejudice to the foregoing powers, to exercise all powers specified in this act. Then lordship may kindly, my lord, come to, my lord, section 55. Power to acquire, hold, or dispose of property. Anchalik Panchayat shall have the power to acquire, hold, and dispose of property, and to enter into contract, provided that in all cases of acquisition or disposal of immovable property, the Anchalik Panchayat shall obtain the previous approval of the government through Jilla Parishad. All roads so and so. Then subsection 3, the state government may allocate to an Anchalik Panchayat any public property situated within its jurisdiction, and thereupon such property shall vest in and come under the control of the Anchalik Panchayat. Where an Anchalik Panchayat requires land to carry out any of the purpose of this act, it may negotiate with the persons having interest in the said land, and if it fails to reach at an agreement, it may make an application to the Deputy Commissioner of the district or acquisition of land, who may, if he is satisfied that the land is required for a public purpose, take steps.
Gone. Very hot. Ventilation. Yeah, very hot, I think.
Due to the outside, it is rising sometimes.
Yes.
Then, section 57, provides for taxation, tax collection of taxes, and in this case, lordship kindly turn to page 70, subsection F. Levy a tax on profession, trades, calling, manufacture, and productive, save and accept those levied under any provision of this act or under any enactment of the time.
70.
No, my lord, it is 57. Section 57.
Now, how does this, where is the role of the Anchalik Panchayat in setting up a market?
Because they propose to establish a market. Now they have to acquire the land, because it is not a private market.
Okay.
Then if the proposal should be routed through the Jilla Parishad to the government. That is section 55. Provided that in all cases of
No, so have the land been identified and has it been allocated?
But since it has not been identified, so it should be identified by the district commissioner or the civil duty officer. And if they held that it is necessary, Because my lord, it is not our.
Where is your power to hold the market as on date?
No, my lord, we are not holding because, my lord, it was proposed by the Anchalik Panchayat, then it was, my lord, approved by the, my lord, Anchalik Panchayat, and the Jilla Parishad, the chief executive officer was directed to establish the market. That is page 32.
Let us see your prayer.
It is our prayer to establish, my lord.
Your prayer is only to set aside the order.
Then, my lord,
Why should it be set aside?
because by the same officer who inquired.
No, Mr. Counsel. When the provisions of the act has not been followed for you to run a market, that means permission has not been given till now. And when permission has not been given, how can you run the market?
My lord, actually, it was not illegal, it was irregular. My subject lordship.
No. You see, when a thing is to be done in a certain manner,
Hello.
when you have got to follow the Panchayat Act,
Hello.
then it has to be done in that manner. There's nothing as, what do you mean is irregular? It's not done as per the act, that's all.
Because, my lord, page 48, the president of the Anchalik Panchayat, my lord, established the market as per the, my lord.
Mr. Counsel, let the President of India establish the market also. But as per the Panchayat Act, it has to be done in a particular manner.
Because, my lord,
Okay.
so
So you see, it is not whether he is the president or the general secretary or the vice president or prime minister of the Panchayat, the Panchayat Panchayat. It is, the fact is that the Panchayat Act has to be followed.
yes, that is.
Then if it has to be followed, then there is, as on date, you don't have the permission to run it. When you don't have the permission to run it, what was the wrong in the order being issued asking you not to run it?
It is stop, my lord.
Huh?
So my submission before lordship, my lord, we need the market, my lord. So, my lord,
You need the market, then please
please
change your prayers.
my lord,
Please withdraw this writ petition and mold the
Yes,
writ
my lord,
petition to a certain,
yes, my lord,
not in the manner, this has to be dismissed. There's no case.
with liberty to file fresh. Your lord. My lord, that is right.
You go to the authorities
Yes.
and then you pray. Yeah. There's no case here.
The lordship may kindly, my lord, to approve the petition with the observation that we approve the authority, my lord, and they will consider.
No, yeah, that is always there, already there. Out here, there's nothing.
Yeah.
I can allow you to withdraw, that's all.
Yes.
And if you want, you can file a fresh with a different cause of action, not same cause of action. That way I can write.
Yes,
that way.
we approve the authority,
Because
but
that is, you see, out here you are only praying for setting aside that order. There's nothing illegal there.
yes, I have seen.
Right. Heard, Mr.
DAKU.
Huh?
DAKU.
The Kayyum, learned counsel for the petition. Also heard Miss Udas for 2 and 4. Anybody else? Miss P. Thapa on behalf of Mr. S. Datta. Learned counsel for the respondent. The petitioner has put to challenge the order dated 1/3/2024 issued by the District Development Commissioner, Golpara, stopping the functioning of the Buduchar Jal Jali dairy market on the ground that the inquiry conducted prior to the inquiry conducted on the basis of which the impugned order has been issued had been done behind the back of the petition. That's the case.
And the inquiry officer also on the District Development Commission.
Further, the inquiry officer was also the District Development Commissioner who had issued the inquiry, the impugned order dated 1/3/2020. The next para, the petitioner's case is that the Buduchar daily market had been settled with the respondent number 5 pursuant to tender process. However, on the request of the concerned MLA, who was aware of the hardships being faced by the people living in the said area, comma. A new Buduchar Jalim daily market was opened with effect from 9/1/2024. The petitioner's counsel submits that the state government has not allotted land for the new market, even though the general
General Standing Committee.
general permanent committee,
It should be General Standing Committee.
huh?
General Standing Committee.
The general standing committee of the Matya Anchalik Panchayat had resolved that the new Buduchar Jali daily market should be established in its meeting resolution held on 5/1/2024. Next para. Mrs. U Das, the learned counsel for the respondent, number 3 submits. 3 and 4 submits that.
2 and 4.
2 and 4 submits that. There is no approval given by the government for setting up the new Buduchar Jali daily market in terms of the Panchayat Act, 1994, hereinafter referred to as the Act. He accordingly submits that when no approval has been given by the state government for running a new market, the issuance of the impugned order directing the closure of the new market cannot be faulted. So am I dismissing or what am I going to do?
I will do this petition. I will leave it to
Okay.
approach the authority.
And next, right. As per the provisions of the Act, once the Anchalik Panchayat holds a meeting and decides to open a new new market, the approval of the government is necessary, in as much as the government is to provide the land for the new market. The same thereafter is to be looked after. The said land is thereafter to be looked after by the Zila Parishad.
Actually,
No.
yes, madam. The proposal should be routed through to the government through the Zila Parishad.
Okay.
Section 55.
The said land is thereafter to be allocated to the Anchalik Panchayat. Where is the Zila Parishad's role?
But proviso, my lord, that provided that in all cases of acquisition of or disposal of immovable property.
Which section?
Section 55, madam, proviso.
So where is the
To section 55. Provided that in all cases of acquisition or disposal of immovable property, the Council of Panchayat shall obtain the previous approval of the government through the Zila Parishad.
In all cases of acquisition of land, the approval of the Zila Parishad is also to be obtained. in the present case, there has been no approval given by the state government to open the new market, and the impugned order dated 1/3/24 shows that the petitioners could not produce any documentary evidence of the public meeting held for opening the new market. The above issues are basically relating to questions of fact and the approval to be given by the state government. Mr. D. A. Qayyum, learned counsel for the petitioner, at this stage submits that he may be allowed to withdraw the writ petition with liberty to file afresh
With liberty to approach.
with liberty to approach the appropriate authority
Yes.
for grant of approval for running the new market. As the same is not objected to by the counsel for the respondents, the writ petition is dismissed with, is closed, as withdrawn. With liberty to the petitioner to approach the appropriate authorities. That's all.
33.
Yes, okay, yeah, Mr. J. Kalita. Submits that he has filed Wakalat Nama on behalf of the respondent number 1 and needs 3 weeks time to file affidavit in opposition. Praise the Lord, this is the matter of the 3 weeks.
If possible, my lord, subject to lordship's convenience, may I get a date, my lord?
2024 matter, will come for the first time.
All right.
34 orders.
No one appears for the petition. The matter pertains to the direction passed by this court directing the respondents to consider the petitioner's representation. What to do? Last time it was listed was in the year 2022, 2 years back. And it's only with regard to representation. Right. In the interest of justice, list the matter. January 1st week, second week.
35.
No one appears for the petition on call. The orders and office notes issued by this court show that no steps have been taken for service of notice upon the respondents number 1, 2, 3, and 5 since the year 2018. It appears that the petitioner is not interested in pursuing the matter. Accordingly, the writ petition, the contempt petition stands closed.
37.
Infectious?
Not infectious.
Why?
The matter is already pending is completed. Let the matter become for admission, my lord. In IA, my lord, they have to file decline.
What is the matter about?
Matter, my lord, we are selling in a eviction notice, my lord.
Item?
Eviction notice.
Eviction notice.
Okay.
Give me the main case.
Doctor will find at page 27.
So a new building has come up or what?
No,
But we have already handed over the entire plot of land to the for the MOU. But because of the fee order, we are not. Although the petition standing contract was already over in the year 2018. Despite of that, they are occupied by.
Yes, what is your case?
my lord, actually what happened, my lord, while this notice was served to me, page 27, my lord. My lord, at that time, my lord, there were near about 100 of so only we have been served copy.
Huh?
At that time, my lord, only we have been served copy only by adopting the choose and pick manner to give the allotment to the other their favorite person.
Well, now
But
they've said,
now, my lord, this case is total separate, my lord. Already, my lord, notice has been served to another person, my lord. This entire land has been handed over to the authority, railway authority. In this regard, my lord, due to the pendency of this case and operating of the history order, my lord, we have not been served any notice till date. And otherwise, my lord, what happened, my lord, we have submitted the representation before the authority concerned on the basis of the letter issued by the authority.
no, you tell me one thing.
That is another case, my lord. That case is still pending, my lord. That case is still pending, my lord. We have filed. It will come, my lord. One thing, my lord, they have filed this already, my lord. This case. Otherwise, after signature of the MOU, execution of the MOU, my lord, this eviction notice should be set aside by the authority, and accordingly, fresh notice may be served to us, my lord.
No, you tell me, what is your right?
I have no-
Your contract has expired.
No, no.
The end of the
At
matter.
that time, my lord, actually, we have no right.
Then
While they have issued this notice, my lord,
what you
with
who's
some vested interest, my lord. That
Mr. Counselor, whatever it is, you have got no whether
now
you
as
have
on
got no
today, my
right.
lord, as on today, my lord, this case is nothing, my lord.
Then that's what I'm saying. Then we close this case.
My lord, as on that, my lord, this case is nothing. My lord, one pair is that, my lord. All are already served the copy for eviction copy, my lord. My lord, we may be treated similarly with the other parts of my lord.
No, what are you challenging here?
That is another,
No case.
that is another, my lord. Can you see this is the notice, fresh notice. This is the fresh
Letter
notice.
dated 8/11/18. Where is this 8/11/18? That's all.
It is
No need of fresh notice. There's nothing here. Right. You cannot carry on. This is development projects, and this is you're occupying the place on the basis of some agreement, and there's stay order. And stay order, unfortunately, this case was last listed on 22. No more.
my lord, present development, I have no grievance, my lord. At present development.
Then you leave.
At that time, my lord, we have grievance, my lord. What project they have supposed to be built up, that is false, my lord. I have submitted all documents at that time, my lord. Now, my lord, this notice, my lord, what I have submitted before you.
No, I'm not on that.
No.
You see, this order was passed in 2018.
My lord, another purpose, my lord.
whatever it be.
Yes, at this,
But
at this stage, my lord,
you are,
this is nothing, my lord.
Huh?
At this stage, my lord, after issuance of, after execution of the disagreement, my lord, I have no right, my lord. I have already made the payer before the authority as per their allotment letter to another place, my lord. That is another case is pending before your lordship, my lord. We
Yeah.
have made.
you see, I am,
This is,
I-
this
I-
case is otherwise infractuous, my lord.
that is what I said in the very beginning. You said no. That's what I said. I told you it's infractuous. You said no. That's why I'm going to make it
Otherwise,
infractuous now.
Infractuous, my lord, after execution of that agreement, my lord.
Then you withdraw this thing that is infractuous. You pursue that other matter.
That is pending already, my lord.
Then you pursue that. You say that is infractuous, or you want me to dismiss it?
No, I will. I leave it up to you, lordship.
No, I'll leave it. You see, Mr. Counsel, in the morning, as soon as this case was called, I told you this is infractuous. You said no, it is not infractuous. So that is why I want to be very clear. You want to withdraw, you withdraw as infractuous, or I pass an order and I decide however I want, which can affect your other cases. So what?
Withdraw.
Mr. D. Barwa, learned counsel for the petitioner, submits that he would like to withdraw the writ petition as the same has become infractuous. Mr. R.M. Das appears for the ASTC, while Ms. M.D. Bora appears for the Transport Department. In view of the prayer made by Mr. D. Barwa, learned counsel for the petitioner, the writ petition dismissed as infractuous. Interim orders passed earlier and interim order passed earlier stands vacated. Then IA will be, in view of the order passed in the main case, the IA is also disposed of accordingly. Probably money is not.
Admitted amount of bill.
I know, but then
Very small amount.
you see, madam, you see what they have been saying. They have been saying that your proposal has been sent for sanctioning funds.
Since long they have been.
Now, what is happening? Christmas is coming also. She needs to buy presents for her grandchildren. Father Christmas. What to do? Where is he? Where is he coming? He's in legs. Not for he won't be legs throughout. He'll be huh? Okay, we'll wait for some time.
Item 39, production is static one.
Okay, for location. 2263.
Yes.
But this is a review. But whether this application will be applicable in a review. So you mean to say this review petition has to be considered to be a review petition under 2263? Or 226, I mean. How can it be? No, that is gone. That is finished. Now, what is this case passed by whom? Okay, passed in 21 by Justice Dekha.
There is no explanation, not one paragraph. For the petition from itself, the review is not vetted. a single para.
Yes, so the order was for allowing for giving them sale permission.
Yes, my lord.
Now, what is wrong with the order?
No, my lord, lordship will kindly see, my lord. The operative portion, my lord, at page 161 of that order. Now, so far as my lord limitation is concerned, this is the review application, of course, my lord, filed under Article 215. And my lord, it is not an application per se under the provisions of Section 114 CPC read with Order 47 Rule 1 and 2, my lord. And then, my lord, we have spelled out from the very beginning till date of filing of the review petition what has transpired. So that amounts to, my lord, in my respectful submission, explanation of the facts for, my lord, instituting the review application if any delay is caused. And one.
No, I'm not on that.
Yeah, now.
I'm on the merit.
Merit, yes, my lord. Lordship, kindly see, my lord, page 161. I am reading the, my lord, operative portion. In the present case in hand, no such move had been initiated from the Deputy Commissioner Dibrugarh, inasmuch as the affidavit filed by the respondent number 3 is totally silent in that regard. In view of the stand taken by respondent number 3 in the affidavit in opposition, and considering the pressing need of the petitioners in order to complete the sale transaction, this writ petition is disposed of with a direction to the respondent number 3 to take steps as per government circular number so and so dated 26/3/2001. Now, this has been quoted in the order itself. Lordship will kindly see. And after, Lordship will kindly mark this, my lord. And after obtaining the necessary approval from the government, the sale permissions applied by the petitioner shall be taken up for consideration as per prevalent laws, rules holding the field. Now, here, my lord, this order, if I may be allowed, my lord, this order contains two parts. Now, my lord, in terms of the circulars issued by the government of Assam in the Revenue Department from time to time, this is one such circular which has been quoted in the order itself and which was a part of the affidavit in opposition filed by the District Commissioner, Deputy Commissioner Dibrugarh. Now, this order says that the Deputy Commissioner will, my lord, send all the papers to the department, and the department, that is the government, will accord necessary approval in as per prevalent laws, rules holding the field. Now, my specific pleaded case out here in the review petition is that this order is not implementable in view of specific bar created under the Assam Fixation of Ceiling Act 19.
Then why don't you file an appeal?
No, the appeal is of course there, my lord, but in review, why I am filing this review? Because it amounts to, my lord, this order cannot be implemented at all. Now,
That is appeal. There's a ground for appeal. Where is the
because
error apparent on the face of the record? We do not know. It has to go. It has to be done by where you've got to think and then come to a reasoning.
Yes, of course.
So when the
Of
reasoning is required,
yes,
and unless you show me those documents, then unless I have that in my knowledge, how can it be done? Now it's correct. What has been done? Now, if it's wrong, you go in appeal. You've got a ground for appeal. There's no bar to file an appeal.
no, there is no bar. But
Yeah.
my lord, I have.
And that is the proper way. How can you do that? Where's the error? Just tell me what is the error in this order?
Error, my lord. Yes. Now that if I might not submit on reasoning, it will not be a appeal. My lord, review.
Correct.
It will be an appeal. I admit
It has prima facie straight away on looking at it.
Yes.
There should be an error apparent on the face of it.
Now, my lord, I am on the third condition, my lord. Any other sufficient cause? Of course, third condition has to be analogous with the earlier two.
Naturally, it has to be analogous.
Analogous with the earlier two, one, my lord.
Yeah.
Now, that is my limited, my lord.
Limited prayer fails, and I think it has
submission,
to.
my lord. Only to that extent, my lord. That because we can see about the matter. Now, Lordship will kindly appreciate.
No. You see, there are Supreme Court judgments also which say
one
that
decision.
court should not pass orders that cannot be implemented.
Yes.
Okay, there are judgments. But that issue is not here. That is not an issue that has been taken up by either of you.
Look,
It is not your case here. that this is not implementable.
No, no.
Now that has to be understood by way of looking into that document that you're talking about, or that rule or whatever. And then it requires reasoning and then on the basis of reasoning, if we come to that conclusion, that cannot be a ground for review.
No, therefore, my lord, why I am seeking a review, that's only, my lord, for a clarification of this order.
When you ask for a clarification, don't ask for a review.
No, review, because court will have to review and my lord, speak of
Sorry, sorry.
clarification. My lord, one,
The content is pending. Content
no, in the contempt application, in the contempt application, we have filed an affidavit stating, my lord, that we cannot implement it because there is specific bar. We cannot, because the statute.
Show me that bar, show me that statute.
Yes. Statute lordship will kindly see, my lord. The fixation of ceiling at 1956.
Yes, give me
Yes,
that.
yes,
That is
I'm-
going to be the ground for rejection of this review petition. Give me that. Naturally, it has to be the ground. Now I need to use my gray cells as to whether that thing is going to apply here or not. It's not an error apparent on the face of the record.
Lordship will kindly take up that section 4, my lord.
Section 4. Yes.
Here, my lord, on the next page, my lord, I have marked it in a red tick, my lord,
Yes.
for that provision.
Notwithstanding.
Yes, notwithstanding. So it cannot be alienated. So T can.
Notwithstanding anything in the contrary in any law, customs, or agreement, no person shall be entitled to hold as owner, tenant, or mortgage in possession of land for special cultivation of tea.
Yes.
Uh,
Now here.
So
my
this is tea land,
tea
tea
land.
estate.
It is tea land. So it cannot be hold as a, my lord, by it either it has to be used for tea cultivation or it has to be declared as a surplus. And then it will go to.
You go in appeal. We cannot rehear a matter and decide afresh.
One
It is
decision.
it is an appeal in disguise, basically.
Based on the executive instruction, pursuant to this statute, there is an executive instruction issued by the state government. And the deputy commissioner has relied on that executive instruction to edit the affidavit. And that affidavit, that memorandum number and it is also quoted.
You're helping him.
I'm making a feeble try, my lord. Lordship may peruse this one decision. I am just searching, my lord. I am only.
No. You have got to help me also to understand. You see, no one is an expert. And we're all learning. And in fact, I'm learning from you all. I'm not the other way around.
My lord.
Where are we? Yes.
I'm so obliged. But in that matter, my lord, while I was searching, Lordship may kindly come to paragraph 23 of the decision. There, what had happened, my lord? Some.
You're using Manupatra. Okay.
Now, my lord.
Para 23.
Para 23. But the facts of the case in that case was that, my lord.
If it was COVID times.
My lord, I could not.
We'll have to use hand wash.
Finally, say hard paper copy, my lord.
No, not an issue. Yes, 23.
Para 20. Now, what had happened there, my lord? I'm just spelling it out. But before the Honorable Bombay High Court, there is a practice, my lord, that in case of consent orders, my lord, the advocates on record, my lord, of both the parties, they have to sign a minute of the order. It is there. Now, one writ proceeding was initiated, and some arbitration matters were also initiated. And my lord, it culminated into some compromise. And then, my lord, that order was signed. Now, when that order was put to implementation, on field, it was found that that order could not have been implemented because there are some other persons also who were not parties before the writ petitioner.
And whose rights were affected?
Whose rights were affected? Now, matter went to the Supreme Court. There also, my lord, one review application was filed. One review application was filed, and finally, the Honorable Apex Court came to the finding, my lord, there that Honorable Apex Court, my lord, disposed of all the review applications and everything only because of the fact that that order passed in writ proceedings could not be implemented. So therefore, my lord, the writ petition was refined. Writ petition was refined. So if my respectful submission would be, if on the face of the record, Lordship is satisfied, on the face of the materials, my lord, I have justified in my review application, my lord, and my arguments, substantiate with my lord, the provisions of the statute, then my lordship can review this order and my lord does it.
But won't it amount to rehearing an issue?
Yeah, my lord, the apex court has.
Apex court has got vast powers under 141, 42.
141, of course. Well, I am trying, my lord. Here, there, I am trying, my lord.
No, no, then
Save my
what
petition.
do you say when he hits me with a judgment passed by the Supreme Court which says that a review cannot be, cannot be an appeal in this case?
Katana, my lord. I bow down to that. I
Then?
bow down to that. That is the only exception I found, my lord. I'm just because it is very hard to argue in a review matter, of course.
Correct,
Yeah.
correct. Then you should have gracefully withdrawn this and said that you go and file an appeal. You know that this appeal, in an appeal they've got everything. Everything is open to you. And there are judgments, enough judgments, which says that
Yes.
courts cannot pass unimplementable orders, orders which cannot be implemented.
So why not dismiss the withdrawal? Because withdrawal might not have some difficulty.
Correct, correct. No, that is his stand. I'm not going into the merits of, his arguments or his submission. You see, but the very fact that he had to go through a round of reasoning by taking,
Yes.
taking help of the statute to change my mind with regard to what has been directed before, so that it does not come in within the provisions of the review definition. That's all.
Yeah, about that.
Yes, yes. This has been pending since when?
24, my lord.
Oh, you have come so late. Huh? This order was passed when? 21.
21.
And you came in 24.
24. Because my lord, we no, why we came late? We could have said of order matter. They cannot my lord, hold us on contempt because approval has to be given by the government. For that reason, I had taken a chance, my lord, by filing this review petition. If it can be clarified, well, to that extent. Because that order contains two parts. EC will send a proposal, government will accord.
I'm not going to.
Therefore.
Why should I? That is again going into, some issues that were not raised.
Therefore, I'm so grateful, my lord. But then again, because
Yeah, you file an appeal.
my lord,
Heard Mr. R. Bor Pujari, Learned Counsel for the review petitioners,
petitioners, my lord.
and Mr. R. Chakrabarti for the lead petitioner.
Lead petitioners, respondents. All
Lead
the
petitioners / respondents.
respondents, my lord.
The writ petition had been filed seeking a direction to be issued to the review petitioners to give the required permission to give the required necessary sale permission for sale of land, sale of their lands. Huh? For sale of their apartments. For sale of their apartments. As the sale transactions for the said apartments could not be completed due to the inaction of the review petitioner in not granting the required sale permission. Next paragraph. This court, while order dated 4/8/2021, passed in WPC 2789/2019, directed the review petitioners, directed the Deputy Commission, District Commissioner, Dibrugarh.
Yes, my lord.
You say Deputy Commissioner / District Commissioner. I don't know why they changed this name. Everywhere in India, it's Deputy Commissioner.
Here, my lord, it will be review petitioner number 3,
I know. Just
Same
like
number,
Deputy
same.
Commissioner / District Commissioner, Dibrugarh,
my lord.
to take steps as per Government Circular Number RSS full stop 573/94/25 dated 26/3/2001, and after obtaining the necessary approval from the government, the sale permissions applied by the petitioners should be taken up for consideration as per the relevant law / rules holding the field. Next paragraph. The review petitioners have filed this present appeal, review petition.
Grounds lordship will precisely find that.
No, wait, before ground. Let me see the delay. File the present review petition. When did you file it?
Well, it was
On 25/4/24.
it was
That is. How many months is that? That is nearly after 3 years.
yes.
How many years? That is nearly after
365. One.
nearly after 2 years, 8 months. Next paragraph. The counsel for the review petitioner submits that the order dated 4/8/21 passed in WPC 2789/2019 needs to be reviewed in view of the fact that the said impugned order is not implementable in terms of Section 4(2) of the Assam Fixation of Ceiling on Land Holdings Act, 1956.
As well as, my lord, other provisions in that act is also there.
Besides the other provisions of the above said act.
I'm so agree.
That's all. He submits that the land of the writ petitioners is tea plantation land. And as such, as such, sale permission cannot be given for the said land in terms of the Assam Fixation of Ceiling on Land Holdings Act 1956, hereinafter referred to as the Act. That's all.
Yes,
Anything else? One more.
Yes, my lord.
Next para.
Besides, my lord, the statutory bar, there are a series of, my lord, notifications and OMs issued by the department. That under that also, my lord, those notifications and OMs.
Mr. R. Borpujari, learned counsel for the review petitioners further submits that a series of notifications and office memorandums have been issued by the government of Assam, barring the grant of sale permission of land, which is a part of a tea plantation.
Tea plantation.
Anything else?
Tea periodic patta.
Yeah?
Tea periodic patta.
There are tea plantations bearing tea periodic pattas. Now, which are tea periodic pattas?
And those notifications, I have annexed D series.
Full stop.
Annexed D series.
He submits that those notifications and office memorandums are a part of the review petition as D series,
D series, well, from 162 onward. Page 162.
which is from page 162 to.
Yeah.
Just tell me, I'll write down.
Yes, ma'am.
No, it's helping the other side. Page 162 to.
It starts from.
How many pages? How many pages? The more the merrier.
185.
Huh?
185.
185. 162, 185. Okay, the petitioner, next para. The review petitioners council submits that in view of, so which clause are you relying upon in the review provision? Which specific one, that special conditions or special reasons?
Yes, my lord, that other sufficient cause.
Other
Yes, my lord,
sufficient
my lord,
cause.
my respectful submission, my lord, that,
And why couldn't you produce these documents at that time?
my lord,
Why couldn't you produce these documents and the law at that time?
yes, it was not produced. Somehow it was not produced.
Okay, right. He submits that the above office memorandums and notifications could not be produced by the review petitioners at the time of disposal of WPC number so and so, due to inadvertence.
My lord.
Due to inadvertence. That's all. Anything else?
Those were, yes,
You can carry on, tell me.
no, my that was.
Huh?
And this, my lord, at 161, which lordship has just now seen, my lord, the honorable single judge's order. My lord, my submission is, my lord, there is an error apparent on the face of the record. My lord, so far as, my lord, the operative portion is concerned.
He accordingly submits that the decision of that the direction passed by this court in the impugned order in the impugned order is an error apparent on the face of the record.
That much.
Full stop. Mr. R. Chakrabarti, learned counsel for the writ petitioners, submits that there is no error on the there's no error apparent on the face of the record, and what the review petitioners are attempting to do is to have a rehearing of the entire matter. What else? He also submits that.
But let's say, periodic paternal can be converted.
Give me one example.
That is one of the executive authorities in the government itself.
He also submits that the stand of the review petitioners that no sale permission can be given to tea plantation land is wrong in as much as the which one?
It is 160.
That circular, this one, in as much as the government circular, which was the government circular number RSS full stop 573/94/25 dated 26/3/2001, which was to be applied by the respondent number 3, by the deputy commissioner / district commissioner for disposing of the case of the writ petitioner, allows for the grant of sale permission of, what did you say? Allows for the grant of allows for the grant of sale permission and alienation of tea garden land for any other use. Which is to the effect that review petition you cannot annex. He also submits that the various notifications and various notifications which are at page number 120 to 128 of the review petition. Shows the various is this approval or what?
What would be the RTI?
Yes, yes.
One from 121.
They are what the approval for sale of land are examples of sale examples of sale permission given by the respondent authorities.
That allows
Are notifications which allow for grant of sale permission, sale slash alienation permission of tea garden land. He accordingly submits that there being no error apparent on the face of the record, the review petition should be dismissed. Full stop. I have heard the learned counsels for the party. The arguments advanced by both the parties goes to show that the entire matter would have to be reheard if we have to be reheard and decided afresh. If all the issues, if all the submissions made by the parties and the documents that they rely upon are again taken into consideration. In the case of so-and-so versus so-and-so, the Supreme Court has held that a review petition cannot be in the guise of, an appeal cannot be in the guise of a review petition. Next paragraph. The stand of the review petitioners that the provisions of the Act do not provide for the grant of sale permission or permission to alienate tea garden land for any other use requires this court to go into the provisions of the Act at length, and that, in the view of this court, would not come within the meaning of review as provided in the CPC and the decision and the law settled by the Supreme Court. Anyway, I'll dispose it later. Dismiss. Okay. I you say in the order, it's also dismiss. It's also dismissed accordingly. Huh? We have to say that. Otherwise, you see, once we start saying that, you'll want it in every order, sometimes we might miss out. We say that it gets merged. You see, once we start saying that, every order now it'll be required. Then next time the respondents will say, there is no order vacating the earlier interim order. So it's a given thing. It will cause problems in the future.
And so applies with.
Article 40.
I seeking a lordship directions against the respondent for vacating the official quarters. It came up last week. Lordship, my instructions are that they have in fact vacated and we've gotten possession. So there nothing remains in our eye.
Yeah, but he says that she says nothing there. So it's not your writ petition.
Not my
He-
application.
It's her writ petition, not your writ petition. Okay, in the main case, or in
No,
the,
lordship,
in
the
the IA,
application, yes.
in the IA. Miss
G. Goswami.
G. Goswami, learned counsel for the applicant, submits that the application has become infructuous in as much as the concerned respondents have vacated the official quarter of the Pukan Pukuriti estate. Mr. S. Who appears? Mr. S.R. Barwa appears for? Huh? One, two, and three. While Mr. R. Jyoti appears for? Respondent number 8 and 14. In view of the submission made by the applicant's counsel, the IA stands closed as infructuous. Then in the main case, what is to be done here?
Lordship, there was a settlement. Now they want to renege on that.
They want that,
They want
yes.
gratuity and provident fund extra.
That they want that.
Extra.
Acha,
Lordship, may
is
listed
that
for
order from here, you put one copy here, because I think I put it here. Just in the I think I've given the story a little bit.
in the previous 25th November,
Yes, yes,
25th November order, last order.
yes, I think, so this is, everything is here.
Yes, Your Lordship.
Okay, that's right. And so what is to be done in this? You file an affidavit in the thing, okay.
No, you filed an affidavit in the application. Lordship, they had
Okay.
also filed a suit. So last occasion, you had directed them to submit that
Oh,
certified copy of that suit.
okay,
and-
okay, that is, I think because of this order, they have vacated.
Yes, perhaps, Your Lordship.
Probably, because, yes,
Yes.
you had filed a
Good
suit
since
also.
last time, yes. So they filed the certified copy of the status quo order of the civil court and the plate.
What has happened to that case?
They'll probably withdraw that.
But that is now, since you'll have vacated, you'll have to go out now. I mean, you'll have to withdraw that case now. Now, what is to be done here? We have to, it's out for hearing now. All
Yes,
the-
Your Lordship,
that's
keep
all.
posted for hearing.
Okay, right. Miss so-and-so appears for the petitioner, while Mr. S.R. Barwa appears for so-and-so, Mr. So-and-so appears for so-and-so, huh? Then you're right. The order dated 25/11/2024 passed in IAC 2422/2024 is reproduced herein below as follows. Huh? Then you're right. IAC 2422/2024 was disposed of today. That is 4/12/2024 on the submission made by the petitioner's counsel that the respondents number 8 and 12
8, 11 and 14.
and 8, 11 and
14.
14 advocated the official quarters of the TSK. The petitions council submits that the only issue left to be decided is with regard to the claim made by the private respondents that they should be given provident fund and gratuity beyond the settlement made on 22/2/2022. Accordingly, this is matter. When? After?
After the
After the
before
vacation.
vacation,
After the vacation.
obliged.
Time being item 38.
38. Make it after Bihu then. Sent. Approved. Sent. So ceiling proposal has been sent, just wait, this is the last. Once ceiling proposal is sent, if it is approved, then you'll get it. Let's wait for them. When will it be done? Huh? 24/11. Right, Mr. Dean had submit that the ceiling proposal for payment of money to will be sent to the finance department for approval. Huh? I have sent that the ceiling proposal has been sent by the chief engineer to the secretariat. Which secretariat? PWD? To the PWD secretariat. For submission to the finance budget section. Finance budget. Accordingly, leave this matter after 2 weeks. Huh? Okay, then on the, leave the matter on 7th, 5th. And then. Okay, what is this? Miss case. Let's see where this will go, huh? That's all.